Good morning. Welcome back to day 2 of the California Privacy Protection Agency board meeting for April 30th and May 1st. It is May 1st, 2026, and we are meeting in person in Sacramento. I'm pleased to be here today with my fellow board members in person and remotely, and to welcome members of the public here in person and many of you joining on Zoom. Before we get started, just a few of my usual quick reminders. Please make sure your microphone is muted when you're not speaking. If you're in person, please silence your cell phone to avoid any interruptions. And excuse me while I do that myself right now. And finally, and importantly, please note that the meeting is being recorded. The meeting is in a hybrid format. Four of my fellow board members, four of us on the board and members of the agency staff are here in person. Board member Alistair McTaggart will be joining us remotely later in the meeting. We continue to offer the public the opportunity to watch and participate in today's meeting virtually or to come in person. We are very committed to providing as much accessibility as possible through these formats. It does create technical complexities, so please bear with us. If we experience any technical issues, we will pause the meeting to address them as needed. Our location today is the Cannabis Control Appeals Panel Hearing Room in Sacramento. We greatly appreciate the CCAP team for their hospitality. Today's meeting will follow the Bagley-Keene Open Meeting Act, as always, and as required by law. The agenda and supporting materials are available here in Sacramento and on the California Privacy Protection Agency website. You may notice board members accessing our laptops, phones, or other devices during the meeting. We are using these devices solely to access board meeting materials. The board welcomes public comment, and I will call for it as we move through our agenda today. Please do note the rules for public comment. Each speaker will have up to 3 minutes to make the comment on an agenda item. Under the Bagley-Keene Open Meeting Act, both board members and members of the public may only discuss items that are listed on the agenda. Accordingly, comments must relate to the agenda item currently being discussed. Please contain your comments to that item. There are 2 exceptions to that rule. One is especially for the public. We have an item for general public comment, number 7 on the agenda for today, and it is helpfully titled Public Comment on Items Not on the Agenda. When we discuss this item, members of the public can comment on any topic, including topics that are not on today's agenda. Please know that the board cannot comment and cannot respond. Second, if you have a suggestion for a topic the board should consider at a future meeting, you can bring that up during the item number 8 today, which is designated for proposing future agenda items. Public participant comment is welcome both in person and via Zoom. After each agenda item, there will be an opportunity for questions and discussion by board members. I will then invite public comment, and each speaker will have their 3 minutes per item. If I happen to forget to call for public comment, please raise your hand on Zoom or wave your hand here in the room. The moderator will make sure you're recognized. If you're joining via Zoom and you wish to speak, please wait till I call for public comment and use the raise your hand feature under reactions at the bottom of your Zoom screen. If you're participating via phone, please strike *9 on your phone, and that will show the moderator that you're raising your hand. When it is your turn, the moderator will call on you and ask you to unmute. Zoom users use your unmute button, and phone users, you can press *6 to unmute. So it's *9 to raise your hand, *6 to unmute. And when you complete your comment, the moderator will mute you again. Please do note that the board cannot see Zoom participants. We'll only be able to hear your voice. If you'd like, you may identify yourself when speaking. This is optional, and you can use a pseudonym when logging in via Zoom as well. Participating in person, if you'd like to comment on an item and you're here in person, please wait for me to call for public comment and then proceed to the podium on my right. When called, please speak very clearly and closely into the microphone so remote participants can hear you and your remarks can be recorded. We apologize, the microphones are temperamental, so you really do have to speak straight into them. And again, we appreciate it if you identify yourself, but it's entirely voluntary. So I mentioned that hybrid meetings can be complex. My thanks to Serena Carwile, our moderator, for managing the technical side of today's meeting, and all the folks who help her if necessary. If you are attending remotely and experience any technical issues, like for example, the audio dropping, we have an email address that you should write to, info@cppa.ca.gov, which is India November Foxtrot Oscar at California Privacy Protection Agency.ca.gov. The inbox is monitored throughout the meeting, and if anything comes up, we'll pause the meeting and fix the problem, resume the meeting when the problem is fixed. Please do note that the 9th item on the agenda today is a closed session item. I will notify the public when we take that item up, and when we are finished with the closed session item, the board will return to the public meeting. We'll take some breaks today, including one for lunch. I will announce each break and any information I have about when we plan to return so that members of the public can leave and come back if they wish before we begin again. My thanks to board members for their service and to everyone helping make today's meeting possible, including Executive Director Tom Kemp and Philip Laird, who are joining us at the front today, and all of the agency team presenting today. I would like to welcome our moderator, Ms. Serena Carwile, and ask her to please conduct the roll call.
Board Member Hamer.
Present.
Board Member Liebert.
Here.
Board Member McTaggart. Board Member Ozer.
Present.
Chair Irvin.
Present.
Madam Chair, you have 4 present board members and 1 absent.
Thank you very much, Ms. Carwile. The board has established a quorum. I would like to remind everyone that we will take a roll call vote on any action items today. Before we get started on agenda item number 2, I would like to take a moment to highlight that the upcoming week, the week of May 4th, is Public Service Recognition Week. This annual California tradition honors all the dedicated individuals who serve our communities at the federal, state, county, and local levels. Especially in today's political climate, I think it's really important that we pause and recognize the remarkable work of public servants and their commitment, expertise, and the effect they have every day on improving the lives of others. And you all have heard me multiple times say this from the podium, but it bears repeating again that we've got the best of the best, the A team of public service at this agency, and we are very, very grateful for your service. On behalf of the CPPA board, I want to extend our sincere appreciation to the staff of the Privacy Agency and across government. We are grateful for your service and your dedication, everything you do. Your work really matters. We'll now turn to agenda item number 2, which is an executive director's update, and will be presented by our executive director, Tom Kemp. Mr. Kemp, please go ahead.
Thank you, Chair Urban, and good morning, board members. I want to provide a quick update on various activities since your last meeting. So first, here are some updates on the Delete Request and Opt-out platform, or commonly referred to as DROP. As of today, there are 285,000 Californians that have signed up in the first 4 months. We expect that there will be accelerated interest in signing up as we near the August 1st deadline for data brokers to begin accessing the system and then performing deletions. Furthermore, I am pleased to share that our Drop Media campaign is now fully activated. Drop ads are running in airports across California, and banners and brochures are being displayed in community locations such as laundromats and convenience stores. Radio and podcast ads are running in both English and Spanish, and our print ads are appearing in multiple languages in ethnic newspapers. We are also in the middle of our Drop Roadshow, where we are taking our booth and informational materials to community events, farmer markets, and universities across the state. This grassroots component of our outreach campaign not only helps more people to sign up for DROP, but also broadens public awareness of the agency. Since our February board meeting, we did publish in late March the data broker registry that showed a record number of data brokers being registered. This increase in registration is, no doubt, a consequence of our bringing nearly a dozen enforcement actions against data brokers, along with our significant engagement with data brokers behind the scenes during ongoing investigations. In addition to the record number of registrations, we published an intuitive new user interface that allows consumers to sort and filter on data collection practices and entities they sell to. I am proud that we have visually unlocked the new transparency obligations that were called for by Senator Becker's SB 361, a bill that the agency supported last year and was signed by the governor. Earlier this week, we also published an update to the registry. This update shows the registry will continuously be enhanced and improved to make it even better for consumers. Californians will also notice an uptick in the number of registered data brokers from the original publication of the registry. There are now over 575 registered data brokers representing over 725 distinct broker-operated websites. I'm also pleased to announce that data brokers now have access to the Drop Sandbox, a test environment that data brokers may use to build and test their integration with Drop for purposes of deletion request processing. Finally, as Ms. Mahoney will mention, I want to personally congratulate the State of Connecticut Senate for passing SB 4, which is the first Delete Act style bill outside of California to get this far. I want to call out in particular Connecticut's Senate Leader Duff and State Senator Maroney for their hard work and commitment to this legislation. Cal Privacy provided technical assistance and shared its learnings from our Drop implementation. As part of Prop 24's mandate for the agency to cooperate with other agencies with jurisdiction over privacy laws, we will continue to engage with any other state to discuss how to develop and implement a Drop-like system. In fact, consider this an open invitation to states considering such proposals to reach out and connect directly with the staff that constructed Drop. We stand ready to share technical details and lessons learned so that the rest of the country does not have to start from scratch when it comes to implementing their own instances of this important tool. Moving to audits, I am incredibly pleased with the progress of our Chief Privacy Auditor, Ms. Ross, and she will provide an update to her work in a future board meeting. But to answer the top question I've heard from journalists, which is, will audits of select businesses begin this year? The answer is yes. Moving to operations and administration, Ms. Chidambara gave a 26-27 budget update where we requested via 2 budget change proposals, known as BCPs, additional resources for both procurement and for enforcement. Please see pages 141 and 142 of the governor's budget for more details. I am pleased to report an update that the Senate Budget Committee Subcommittee number 4 on March 12th unanimously approved our BCPs. On April 29th, this past Tuesday, Assembly Budget Subcommittee number 5 included our BCPs on the agenda as non-presentation items. While the subcommittee has not yet voted on these items, we remain cautiously optimistic that they will be approved. And finally, with respect to the legal team and regulations, the agency issued an invitation for preliminary comments regarding reducing friction in the exercise of privacy rights and opt-out preference signals. That comment period closed, and the comments are now publicly available on our website. We appreciate the 40+ organizations and individuals who provided the agency their feedback. We also opened an invitation for preliminary comments regarding the forthcoming data broker audit requirement under the Delete Act, as well as preliminary comments on employee data and notices and disclosures. Both comment periods close in May, so there is still time for the public to comment. For the omnibus regulations that were approved last year, as Mr. Laird mentioned in the last board meeting, we plan to provide quick guides and compliance checklists for cybersecurity audits, risk assessments, and automated decision-making technology requirements. These are on schedule to be released over the next 6 months, with the risk assessment materials available later this spring. That concludes my updates. I look forward to any questions.
Thank you very much, Mr. Kemp. It's great news about the BCP, and thanks to our partners in the governor's office and the legislature for supporting the work in recognizing that we needed a little bit of additional funding in order to continue this great progress with DROP and with enforcement and other things. So that all sounds really wonderful, and we'll look forward to further updates. Are there questions or comments from board members? Mr. Liebert?
Hey, thank you for that update. In regards to DROP, I'm wondering, it's very natural, I think, that over the last, that's okay, oh, wow, it really does work. Okay, over the last couple of months, I think it makes sense that we'd have kind of a drop off on the expansion of folks joining it. And so I'd love to get just a quick sense on the advertising side, because I think we're in the process of starting to beef up that process as well, right?
Board Member Liebert, that is correct. We're now fully operational on the ads. So it does a nice job of targeting you. So if you're listening to a sports podcast, all of a sudden a drop ad will appear. And we're very proud of the fact that we're going after specific communities in California. We're advertising in laundromats, convenience stores. The signage is in Spanish. And we're also focusing on ethnic newspapers and advertising in multiple newspapers. So we're now fully operational. Just over the last week or two, we finally kind of hit that critical mass. And I think that will drive increased usage and interest in the platform. And then we also know that, you know, some people want to hold off and say, well, I'll get to it later because the deletions don't occur. But the good news is by the time the next board meeting happens, the deletion process will have officially be open, and we'll be able to report back to you on the numbers of registrations, as well as provide some visibility in terms of you know, if any of the data brokers have begun. Now, take into account, they have 45 days to do that. So even into August, and maybe in early September, people still may hold off, but we encourage people just to go ahead and do it. And then furthermore, they can go back, Californians can go back if they have a new zip code, a new email address, a new phone number, and we're going to also be publishing information about how they can get their mobile advertising ID. Sometimes initially people don't understand that, and so we're coming out with additional videos and educational material. So it's perfectly okay for Californians to put in some basic information, like their phone number and email address, but then they can come back. And then they can add additional zip codes, phone numbers, emails, and mobile advertising. So we see this as kind of a living, breathing system in which Californians can come back, update, and then they can check, starting in August, they can see the statuses of their updates as well. So it's a nice kind of a two-way system where people put information in and then they get information out in terms of the statuses of their updates.
In regards to the registration by the data brokers, I think you mentioned a number of like about 575 or so have so far registered. And somehow in one of our meetings, I remember that we think there are many thousands of data brokers out there. And so what are some of the techniques that we are able to use now to try to locate all these other data brokers that are not registered?
Ms. Urban, I think that may be a topic for Mr. Mackow.
Yes, we do have an agenda item on enforcement update. I think that'd be a great question.
Okay, great.
Deputy Director Mackow. Yep.
Great.
Ms. Ozer?
Well, I just wanted to start by saying that that's just an immense amount of work with such a slim staff. So just, you know, deep appreciation for the range of work and the just how quickly this work is moving, because it is a lot for everyone to be handling. One question I had about some of the outreach, has there also sort of been a plan to be connecting with organizations that might work with individuals and sort of have their own outreach capacity, just to make sure that individuals who might have relationships with organizations might sort of get the information about DROP from a trusted source? Because I can imagine that there might be some communities that might be quite fearful about putting information into systems that are government systems. Obviously, the drop system is very protected, but just sort of want to make sure that, as we're trying to reach diverse Californians, sort of thinking about some trusted relationships that might be able to connect with people about the system and that they can trust it.
I'm so glad you brought that up. We have actually had focused outreach to civil society and other community organizations. And so we're trying to meet people where they're at. And we're also, participating in a roadshow where there's oftentimes, community events associated with specific entities and organizations. And then furthermore, we have published what we call Drop in a Box, which is, and it's available on privacy.ca.gov/drop. It's the last menu item on the left, where there's pre-canned templates for emails, newsletters, brochures, et cetera, that can be customized and tailored by individuals or organizations to further promote that. Furthermore, we're now in the process of creating additional videos that will help people utilize Drop, that can also be referenced by communities. Yeah, we can't do it on our own, right? And it's so important to have other organizations, other entities be able to promote this. And it's so nice that sometimes you'll see someone post on Instagram or a tweet or something like that, and we'll literally see a spike. Like 2 weeks ago, a very technical gentleman posted something on Twitter, and that resulted in 24 hours. I'm going to guesstimate probably influenced another 3,000 people signing up within 24 hours. So it's amazing that you just don't know where this can come from in terms of individuals or organizations being able to promote that. We're also trying very hard to work with our sister government agencies. And so I know that we've done webinars with DFPI, CPUC, and others, and we thank them very much for giving us their platform to communicate. We're very appreciative of the governor coming out with a press release. We're very appreciative of the Attorney General not only coming out with a press release, but doing a very funny video with Senator Becker, and also further promoting Drop in press releases that he does on related consumer protection topics as well. So yeah, we're really trying to get as much leverage as possible from other entities, and trying to have this go viral and raise awareness through it. So we just can't do it via advertising. And one particular community that we've really focused on is seniors. And so we've partnered with DFPI, the Contractors Board. We've probably at least done 10 to 15 senior scam stopper events where we heavily promote. I've personally done 3 or 4. So I've been in senior centers talking to senior citizens. We try to provide QR codes and try to make it very easy. Provide our information. So it's from top to bottom, from the public affairs to myself. We're out there in the community, but we know we can do better. And I certainly encourage board members, if you have suggestions or recommendations for particular organizations, all ears. We'll be there talking to them, because it's so important, the value proposition that Drop brings. And we're trying to make it so that Drop is in a box where people can promote it, and we're going to continue to go down that path. So thank you very much.
Thank you, Mr. Kemp. Board Member Hamer?
Yes, thanks. To follow up on the point about some people might be fearful of registering, we learned a lot yesterday, and we already knew that the data brokers are sharing with federal governments. Does part of the educational program include why you want to do this to specific communities that might be fearful of putting themselves out there?
The answer is yes. And we try to do that via FAQs in our presentations. I've participated in at least 10 podcasts, and up to this point, the podcasts have been more focused on the privacy community, because part of that, we want to make sure that businesses are aware of their obligations, and also privacy centric consumers that may listen to these type of podcasts. But we're also in the process right now of reaching out to specific communities and organizations that have podcasts, community TV stations as well, that target specific communities, and we would educate people on that. And that's very common questions that people have, that there is a fear, there is a nervousness that's out there, and even potentially giving their information to us, the state, like, will something bad happen to that? We spend time, walking people through, the security that we have, how the information is used, how the information, once you do the verification, that we have no idea of who the individual is verifying. We just simply know that they're a California resident. So that is very much top of mind. This is going to be something that we need to focus on continuously.
More specifically, are we telling people that data brokers are sharing their information with federal agencies?
That we do give that example, and the good news is that the new registry allows you to filter on what data brokers sell their information to what type of entities. And so today you can go in and you can actually click on, for example, foreign actors, which is a defined term under federal government. There are over 50 data brokers that sell to the federal government, which you can see exactly who they are. So if a Californian does not want to wait until August, they can know exactly who sells it to the federal government, and they can begin doing their manual CCPA deletion request. The filter also will tell you which data brokers sell to Gen AI developers. So there may be concern about personal information being part of large language models as well. So yeah, we do give visibility, and we do educate that these are the type of entities that would be downstream purchasers of your data.
Thank you. Mr. Liebert?
Just a quick reminder about this idea of possibly piggybacking on some notices that go out to millions of people courtesy of the state of California, whether it's the DMV or voter reg. I don't know the legalities of that, but obviously there are notice systems in place already that would be lovely to be able to notify people. This is a state program, right? So something I'd love to hear about if at some point that could be possible.
That's certainly something that we've discussed internally. I don't have anything to update, but I 100% agree that every time it would be great if when you get that car or your driver's license, renewal, that there's a little pink piece of paper with a raccoon and the word drop on it. We're exploring all avenues and activities to promote this. So thank you for, I think we're in sync with your thinkings on this as well.
I think the raccoons are great. They're so cute. And also, we all know they're trash pandas. So they're delightful. To follow up on Board Member Hamer's question and comment, I really recommend that folks look at the registry and do the searches and sort. It's very illuminating. And the additions to the requirements for disclosure in the recent Deletion Act amendments are very helpful to understanding what data brokers are doing. I also want to underscore what Board Member Ozer said in thanking everybody and being impressed by the different levels and types of work from the administration division, making sure that we have the contracts in place to be able to continue to grow at a rapid pace, with drop to, of course, the technical expertise and the regulations required and the public communication we've been talking about. So it's exciting to see this come to fruition for Californians, so thank you. Is there any public comment on this item?
This is for agenda item number 2, Executive Director's Update. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 2, Executive Director's Update. Madam Chair, I'm not seeing any comments at this time.
Thank you very much, Ms. Carwile. In that case, we will move to agenda item number 3, which is a legislative update and possible action authorizing agency positions on some selected pending legislation. It will be presented by Ms. Maureen Mahoney, our Deputy Director of Policy and Legislation. And I'll ask that everybody please turn your attention to the materials for this agenda item. As we admire the sheer multitude of bills that Ms. Mahoney will cover for us in the materials, I'll let the board know that she plans to pause for questions or comments between broad sections of the presentation. So federal, multi-state, and then each California section so that we have a plan for discussion. Thank you, Ms. Mahoney. Please take it away.
Thank you, Chairperson Urban, board members. Very much appreciate the opportunity to discuss our legislative work. And as usual, I wanted to acknowledge my team members, James LaDeblack and Elliot Sangara, for all their work on this. For this item, I'll do several things. First, I'll provide an update on our federal engagement. Second, provide a high-level overview of several of the privacy and tech bills that we're monitoring in states across the country. And then I'll turn to California. I'll give a brief update on Cal Privacy-sponsored bills. Then I'll talk about a number of privacy and tech-related bills in California that we're watching. And at the end, I'll present for board consideration several bills that we recommend the board consider taking a position on. And these specifically amend the CCPA or the DELETE Act. Again, after each section, I will pause. I will say that this is a pretty long presentation. There's a fair amount of material, so try to go slow. And if folks want more or less detail, please let me know. So first, turning to our engagement at the federal level. Between the time that these slides were submitted and this meeting, the House Energy and Commerce Committee filed a federal comprehensive consumer privacy bill, the Secure Data Act, that includes a broad preemption provision seeking to preempt any state privacy law that relates to the provision of the act. This bill is substantially weaker than the California Consumer Privacy Act and would seek to eliminate many existing privacy rights and protections that Californians depend on. We submitted a letter opposing the bill this week where we highlighted just a few of the many major issues with the bill. Separately, House Energy and Commerce Ranking Member Pallone and several privacy advocacy groups highlighted their concerns with the bill as well. Specifically, it would make it substantially harder for California consumers to exercise their privacy rights. For example, while the bill establishes a data broker registry, it doesn't have a global deletion component like DROP. The bill does not require businesses to honor opt-out preference signals, so you wouldn't have this one-step way of stopping the sale and sharing of your personal information. It doesn't have a prohibition on dark patterns, so businesses could nudge consumers into sharing more information they intended. It requires verification when consumers exercise their opt-out rights, creating friction, potential loopholes. And businesses can charge consumers or disregard privacy requests in excess of 2 per business per year. The bill also weakens existing guardrails on businesses. The data minimization provision only applies to collection, not collection, retention, use, and sharing like in California. It doesn't have data retention limits, doesn't require risk assessments. It also has a much narrower definition of sensitive personal information. And finally, the bill has a weak enforcement scheme. Enforcement authority is only granted to the Federal Trade Commission and state attorneys general. There's also a 45-day right to cure that does not expire. So this is just a small sampling of the provisions that are weaker than the CCPA. So in staff's view, it would have a catastrophic effect on Californians' consumer privacy and consumers in many states. A hearing on the bill is expected in May, and we'll continue to do outreach, raise our concerns with the bill, including Executive Director Kemp, who's planning a trip to Washington, D.C. in mid-May. So I'm going a bit out of order on the slides. I'm going to address the Gramm-Leach-Bliley Act bill because an updated bill was formally introduced at the same time as the Secure Data Act. So this bill was the GUARD Financial Data Act from the House Financial Services Committee. So it updates the Gramm-Leach-Bliley Act, which, as you know, is the financial privacy law. It also incorporates broad preemption language, specifically seeking to preempt any state law establishing consumer data privacy or security requirements with respect to a financial institution. So the agency submitted an opposition letter on a draft version of the bill last month, and we expect to submit an opposition letter for this bill now that it's been formally introduced. With respect to artificial intelligence on the federal level, we are monitoring next steps expected from President Trump's December executive order on a national framework for AI. The Secretary of Commerce is expected to publish an evaluation of state AI laws that, in their view, would conflict with a policy announced to enhance United States global AI dominance. And laws that should be referred to the Department of Justice for legal challenge. So this evaluation was expected in March, and it has not yet been released. The administration did release a high-level legislative framework for AI that seeks to preempt the states. But again, this is just a framework and not legislative language, but we may see a draft bill fleshing out those ideas in the coming weeks. And then we may also see continued efforts to place a state AI moratorium in a must-pass bill. So we're monitoring that. And then on children's privacy, we've also been monitoring bills that would amend the Children's Online Privacy Protection Act, or COPA 2.0. The Senate recently passed their version. It has favorable language with respect to the states, explicitly allowing states to adopt stronger protections. So this is the Senate version. Expand opt-in protections to minors under 17, restrict targeted advertising, incorporate purpose use limitations, among other things. So this has passed the Senate. In the House. House is considering their version as well, much less favorable with respect to the states. It includes a preemption provision seeking to preempt state laws that relate to that act. While the House Energy and Commerce Committee was considering that bill, the Senate version passed at the same time. So the House took a step back to continue to work on that proposal. So we're continuing to monitor.
Thank you, Ms. Mahoney. Comments, questions, on the board on the federal? All right, for the, correct me if this is wrong, but for the board and the agency, I will once again repeat that we cannot support any law that has a broad preemption provision in it. We believe that all Americans should have privacy rights. It is unfortunate that this particular bill is so very weak, as well as having a broad preemption. But we can't accept and support, we certainly can't support a law that preempts Californians' privacy rights, in particular the fact that our bill has a floor on protections. It can be amended to further its purposes. I know I've said this multiple times, but I will say it once again for the record, because I think it is important that we continue to make this point. And now that we have nearly 20 states with comprehensive privacy laws, I think it is particularly important for the states to continue to lead. They are developing a pattern of privacy protections And currently, with the behavior of the federal government, it is especially important that states lead. So it's especially important that we don't accept this kind of broad preemption. All right, I've made my little speech. Please continue.
So next, I'd like to do a high-level overview of what we're seeing at the state level.
I apologize, Ms. Mahoney. There was actually something else that I wanted to say, which is that I greatly appreciate the letter that staff put together and sent on the Secure Data Act. It is comprehensive, it is clear, and it is, I think, very informative and helpful to the staff and the members of Congress who seek to understand how that act would interact with our laws and where it would fall short on protections. So it's an especially helpful letter, and thank you for putting it together. I think it must have taken a lot of work to do something that is so substantively good and clear. Thank you.
And again, thanks to my staff for their work on that. So next, I'd like to do a high-level overview of what we're seeing at the state level across the country. So as Executive Director Kemp said, as a reminder, the CCPA directs the agency to work with jurisdictions to try to encourage consistency and privacy protections where possible. So over a dozen states considered privacy laws this year. Several of them have wrapped up for the year already, but bills are still pending in states like Louisiana, Massachusetts, and Pennsylvania, just to mention a few. So this work is ongoing. We have seen 2 states this year adopt comprehensive privacy laws. This is Alabama and Oklahoma, bringing the total number of states with a comprehensive privacy law to, I think, 21 or 22, depending on if you count Florida, which has a pretty high threshold. However, both of these bills are weaker than the CCPA, looking a little bit more like the federal bill that I was talking about, not requiring businesses to honor opt-out preference signals or prohibiting dark patterns. However, delete-style bills grew in popularity this year. 8 states considered delete-style bills, and again, as Executive Director Kemp mentioned, CalPrivacy staff spoke with lawmakers and legislative staff in many of these states to share our experiences in implementing DROP to encourage consistency. And as Executive Director Kemp mentioned, Connecticut's SB4 cleared the Senate and will be up for House vote next. If signed, it'll be the second state to adopt a delete-style bill. Its provisions closely mirror the California Delete Act. And then similar bills are still pending in New York and Vermont. Likewise, very similar to California, the Vermont bill would allow consumers to individually request deletion with data brokers, but for a global deletion component, that's in a study at this time. So that's still pending. And then between the time we submitted the slides and today, Nebraska was considering a bill, but their legislature closed without moving forward on that. But again, staff are committed to being a resource to interested states on all privacy legislation. I'll pause here before I move to the California update.
Thank you. Comments or questions from the board on the multi-state? Yes, please, Mr. Liebert.
Just a congratulations for all the work, because this is exciting, right? We started with the CPPA, and that's been a model across the country. And now we've got our Delete Act, and it's great to see that 8 states are considering this approach, which is really exciting. So keep up that great work.
Thank you. I am delighted that one of my favorite CCPA provisions is on this slide, and appreciate everyone's work to fulfill that role. Please go ahead.
Perfect. I'll now move to California bills. So to give you a sense of where we are in the legislative process, I'll begin with a roadmap of the session. So we've passed the deadline for bills anticipated to have a fiscal impact to make it out of policy committee in the House in which they were introduced. Today is the deadline for non-fiscal bills to advance out of the policy committee. May 15th is the deadline for fiscal bills to make it out of appropriations and head to the floor. And then bills have to be out of the chamber in which they were introduced by May 29th. Then they'll cross over. The process will begin again in the other house. Bills have to be out of the legislature by August 31st of this year. And then the governor has to make his determination by September 30th. And I want to start with an update on the bills that Cal Privacy is sponsoring this session. So first is SB 923 from Senator Becker, the Expanding Privacy Rights Act. And as we've discussed in previous meetings, this bill does two things. It expands the right to delete in the CCPA to cover information collected about a consumer rather than information just collected directly from a consumer. And it makes it easier for consumers to submit privacy requests by requiring online-only businesses with a direct relationship to the consumer to provide an online method for submitting rights to access, delete, and correct. Currently, they just have to provide an email address. So this bill passed the Senate Privacy Committee, that should say Senate Privacy Committee. Well, Senate Privacy Committee is a new committee, so we're still trying to remember that. It's been placed in the suspense file in appropriations, meaning that the committee estimated that the bill would cost more than $50,000 to the general fund or $150,000 to a special fund to implement. So they'll decide on May 14th whether it advances further. Next is AB 2021 from Assemblymember Schiavo. That is the Whistleblower Protection and Privacy Act, and it would add whistleblower protections to the CCPA in two components: anti-retaliation provisions and incentives for whistleblowers to come forward by allowing them to share in the proceeds of a successful action. Unfortunately, it does not look like this bill will advance this year. This is an important and complex bill that would add valuable changes to the CCPA's enforcement framework, including a pipeline for the agency to access information leading to higher quality cases. But we weren't able to have all the necessary conversations before the policy committee deadline to bring the bill along. For example, the Assembly Privacy Committee feels that existing whistleblower protections in the labor code are sufficient, and that if a bill were to introduce financial incentives to a whistleblower program, then it should apply to a broad range of laws and not just the CCPA. But again, not enough time to work together to align around solutions for that. Assemblymember Schiavo, the author, remains committed to the concepts of the bill, and we can look forward to pursuing these ideas again in a future session, and are very grateful for her support. And next, I'm going to provide brief updates on a selection of bills that we're watching because they have to do with the processing of personal information. But we're not recommending that the board take a position at this time. Most of these do not amend the CCPA or the Delete Act or direct our agency to take action. Additionally, because it's still early in the legislative year, many of these bills we can expect will be amended quite a bit over the next few months. We're watching closely to see how they evolve. For bills that staff determines could affect the agency, we may want to bring these back to the board at a future meeting for consideration. And finally, we're highlighting some of these to give the board a sense of the bills that are getting a lot of, and issues that are getting a lot of attention. So I'm going to start with several bills focused on kids, online safety and privacy, which remains a high priority for the legislature this year. This is actually just a sampling of what's been introduced. And again, none of these directly affect the agency. So first is AB 1159 from Assemblymember Addis. This is a 2-year bill that I've talked about in a previous meeting, and at a high level amends student privacy laws to prohibit the use of covered data to train AI systems. This bill has passed the assemblies and the Senate and will continue to monitor this bill. Next is AB 1700 from Assemblymember Lowenthal. This bill would have established an e-safety commission tasked with developing age verification guidelines. This vehicle appears to have stalled out in committee. I will note that a separate bill, AB 1709, from a coalition of assembly members, including Mr. Lowenthal, it introduces a social media ban for minors under 16 and establishes a similar e-safety advisory commission within the Department of Justice that would be tasked with advising the AG on a wide range of issues having to do with harms to kids and age verification issues. So this one is in appropriations, as are most of the bills that I'll be talking about. Next is AB 2007 from Assemblymember Bauer-Cahan. This bill prohibits non-school youth programs from using covered information for any purpose, including marketing purposes, without consent, and prohibits the sale or sharing of covered data. And this bill has passed Assembly Policy Committees and is in appropriations. Next is AB 2023 from Assemblymembers Wicks and Bauer-Cahan. This bill is a companion chatbot bill. As such, requires operators of these tools to do several things with respect to child safety, including verifying age, doing risk assessments, implementing child safety policy. But I'm flagging this bill because it does have a privacy piece. It also restricts operators from targeting ads at children defined as kids under 18 and selling, sharing, or using personal information of a child for any purpose not authorized by the bill. And this bill is also in appropriations. There's also an identical chatbot bill pending in the Senate, SB 1119 from Senator Padilla. And then the last kids privacy bill I'll mention, AB 2246 from Assemblymember Wicks. So this is a modified version of the age appropriate design code. It's in a separate part of the California code than the existing AADC, and it incorporates substantive provisions of that law that have not been enjoined in the lawsuit challenging that law. I will note that the one part of the age appropriate design code that is existing now that affects us is that we have one appointment to the AADC working group to provide legislative recommendations. This new vehicle does not include the Children's Data Protection Working Group. And just as a reminder, we appointed Dr. Jennifer King of Stanford as our appointee before the AADC was enjoined.
I'm sorry, I just have a quick clarifying question. Yeah. But the working group would continue under the existing law that is being challenged, or this would override the working group?
It's unclear. So, I mean, the AADC would still be in one part of the code. This vehicle would be in a different part of the code. It depends on what the authors want to do moving forward. But I just wanted to note that the working group is not in the new vehicle.
I see. Okay, thank you.
It's still up in the air about what will happen. This bill is also in appropriations. Now I'm going to walk through a few workplace surveillance and workplace AI bills that we're watching. They may overlap with, but not conflict in our view with CCPA obligations, and again, do not task our agency with any responsibilities. So first is AB 1883 from Assemblymember Bryan. This bill regulates the use of workplace surveillance tools and employers' use of worker data, including by prohibiting the use of surveillance tools for certain purposes and prohibiting the use of facial recognition technology in the workplace. And then you may recall last year that an employment automated decision-making technology bill passed the legislature, but was vetoed by the governor. That's SB 7 from Senator McNerney. So this year, 2 bills have been introduced that each replicate one portion of the bill. Again, these bills overlap with, but do not conflict with the CCPA ADMT regulations. So the first one is AB 1898 from Assemblymember Schultz. This is a blanket notice requirement for employers to provide employees with notice of the use of all AI tools used by businesses, both automated decision systems and AI surveillance tools. Additionally, the notice provided to employees under this bill must include the results at a high level of the risk assessments performed on any automated decision-making technology in compliance with the CCPA. This bill is also in appropriations. And the second piece, SB 947 from Senator McNerney, is very similar in a lot of ways to SB 7 from last year. It prohibits certain employer uses of automated decision systems, requires human review of certain employment decisions made using automated decision systems, and post-use notice for employees following such decisions. Also in appropriations. And next, I'm going to turn to some key privacy-related bills that we're watching. Again, categorized as watch bills for now because they do not directly implicate the CCPA or agency. Let's see, AB 2169 from Assemblymember Lowenthal. This is a data portability bill that's intended to encourage competition between platforms. And this bill is in the Business and Professions Code. It does two things. It gives consumers the right to request that a social media company or AI model operator provide in easily transferable form a copy of the user's personal information and allows them to port it to another platform. This bill doesn't amend the CCPA or task us with responsibilities. The AG is tasked with rulemaking and enforcement, but we are watching this one closely to make sure it interacts cleanly with the CCPA. Next, AB 2561 from Assemblymember Valencia. Doesn't amend the CCPA. We talked about this one at the last meeting. It was recently amended to restrict operating systems and application providers from undoing a consumer's privacy settings without consent. Next, AB 2564 from Assemblymember Ward. This is a surveillance pricing bill, and this is a hot topic right now across the country. Many states are considering them, and this bill prohibits retailers from engaging in surveillance pricing, defined to mean setting customized prices for a specific consumer or group of consumers based on personally identifiable information collected through electronic surveillance. And next, SB 354 from Senator Limon. This is the Insurance Information and Privacy Protection Act. We've talked about this in a previous meeting. It was introduced last year. It's a 2-year bill. It establishes new privacy protections for insurance entities. In staff's view, provides equal or greater privacy protections in the CCPA and would negate our need to adopt additional regulations to specifically address insurance companies. This bill was recently amended as we were going into the meeting, so we're currently reviewing the updated bill, and that is in the Assembly Insurance Committee. Next, SB 1104 from Senator Cabaldon. This one would affect us. It amends the Delete Act in 2 ways. It would codify the definition of direct relationship that's in the regulations, so put it into the statute. And it adds new disclosure requirements related to how data brokers process and sell inferences about certain sensitive data categories. And then in an amendment to the Government Code, not the Delete Act, it charges the Office of Data and Innovation with developing a privacy preference tool that allows consumers to identify their privacy preferences and use the tool to evaluate businesses' privacy practices. So this one was also undergoing significant amendments heading into this meeting. So rather than recommend taking a position on this bill, we recommend continuing to monitor it as it evolves and may bring it back before the board at a future meeting. And then last, SB 1130 from Senator Reyes. So this bill would amend SIPA in the penal code. It would make it a crime to operate a wearable recording device to capture video or sound of another person in any place where that person has a reasonable expectation of privacy, unless they have the person's consent. It would also make it a crime to disable any lights that would indicate that it's recording. So we're monitoring this one due to concerns about new wearable devices hitting the market.
Thank you, Ms. Mahoney. Sorry for it. I wanted to ask a clarifying question about AB 2561. So that does not amend the CCPA. What does it amend or create?
I believe it's in the Business and Professions Code as a separate standalone.
I see. Thank you.
And there are also about a dozen new bills that we're tracking that establish new administrative requirements for state agencies. Given the number this year, we wanted to put it on the board's radar as a category of bills that we're watching. These would impact the agency, but at this time, we're just making sure any efforts are in coordination with other state entities. And monitoring as they move through the legislature.
Sorry, what's the change to the rulemaking process?
Well, there are several bills this year that would provide amendments to the Administrative Procedures Act. There's one that would require assessment of cost of living impacts that a rule would have. That's AB 2366. There's a bill, SB 986, that would allow the legislature to disapprove a regulation. And there's one requiring an assessment of the benefits and savings of a proposed rule intended to kind of lower the threshold of what would hit major regulation.
Thank you.
Okay, so for the final portion of the presentation, I'm going to walk you through 3 bills that would affect the agency.
Apologies. Would this be, I have chimed in with questions. I apologize for doing that. Does anybody else on the board have questions or comments at this point? Board Member Hamer, please.
Thanks, Tony. So the SB 1130, what's the status of that, and would that apply to the Meta glasses?
I believe so. Yeah, I think that was the intention for the bill. And yeah, the bill is still moving. It's currently in appropriations in the first house, so being assessed for its fiscal impact.
Okay. Are we optimistic?
It's too early to tell at this time, but I'll be happy to keep you updated.
Okay. Thank you.
On AB 1159, the student personal information used for training AI systems, how is student defined? Is that K through 12? Does it include university students?
Yes, so that would amend COPIPA, so that would be K through 12, and then it also amends the privacy law that applies to university students as well.
Okay, right. So anybody who is enrolled as a student, whether in K through 12 or higher education. Okay, thank you. Other comments, questions? Yes, Mr. Liebert?
I'm sure that, that you're all kind of tracking all of these bills in terms of which particular state agencies are being tasked with enforcement efforts and potentially the privacy realm that we're in. And I think it would be helpful for you to alert us at some point about that, because we have a great story to tell in terms of what our agency is now capable to do in terms of enforcement efforts, for example, and just the technological strengths that we have. And so kind of keeping track of that and getting a sense of how this is all being looked at by the legislature in terms of which agencies make the most sense to be doing some of this really important work. That'd be really helpful.
Thank you. Board Member Ozer.
And also just piggybacking on that, just a sense of sort of what the enforcement mechanisms are more generally. In the informational hearing yesterday, there was quite a lot of conversation about, also the importance of a private right of action. So it would just be good to know what actually are the enforcement mechanisms that these bills are considering, so that those bills, if they become law, are not just, can actually be utilized and enforced.
That's great feedback from both of you. So just to make sure I'm understanding correctly in future updates and board meetings, just to make sure that I'm talking about the enforcement mechanisms in each bill.
Yes, and also which particular agencies might be getting tasked with those particular provisions, whether it's the AG's office or technology, whatever that might be. But it'd be nice to see how this is being considered.
Yes, we'll absolutely do that.
Thank you.
Thank you both. Thank you, Ms. Mahoney. Please go ahead.
Okay, so for the final portion, getting into the home stretch a bit, I'm going to walk you through 3 bills that directly affect the agency, either amending the CCPA or the DELETE Act. And actually, before I get into that, I'm going to mention a couple other bills. So I do want to flag a couple bills from 2025 that are 2-year bills that we took a position on last year that are still active. And the first is AB 302 from Assemblymember Bauer-Cahan. This bill amends the DELETE Act. It provides for a process for elected officials and judges to have their personal information deleted from data brokers by having us collect the names of the elected officials, having the Judicial Council send them to us, and we'd submit them to DROP, and then there'd be a 5-day turnaround time for deletion. So we have a supportive amended position on that bill. Second, we have a support position on AB 322 from Assemblymember Ward, which adds new protections for location data, including strict data minimization, prohibiting the sale of such data. And I think it came up yesterday. So again, we have a support position on that bill. These bills are currently parked, but may start moving. And the history on 302 is particularly relevant for AB 883 from Assemblymember Lowenthal. So this is another 2-year bill, but it was gotten amended in early 2025 to mirror in many ways AB 302. Its intent was to give more privacy protections for elected officials and judges, which is, particularly an important goal. But, as it's been amended, it's very, very similar to AB 302 under the bill. Effective January 1st, 2027, the Secretary of State is tasked with providing a list of all elected state and local officials to the agency. However, we would be tasked with going back to those elected officials and checking and making sure they wanted to be included in the list. The Judicial Council is tasked with providing CalPrivacy with a list of California judges to serve as the judge's request for deletion. And under the bill, CalPrivacy submits the deletion request into DROP and then requires DROP to notify the data brokers of these requests and process these requests within 5 days. So again, very similar to AB 302, except the Secretary of State would be required to provide the names to us rather than us collecting them. So we do really appreciate that change. And this bill has passed the Assembly and is now in the Senate. So again, staff very much agrees with the goals of the bill to expand privacy protections to government officers in this time of increasing violence against state officials. But we do flag some issues with implementation. So first, in staff's view, this bill is not feasible without delayed implementation. So again, its requirements would kick in January 1st, 2027. And the technological features required by this bill is something that'll take time and resources to build that the bill does not account for. Second, we do have some privacy and security concerns about the deletion request process. As currently drafted, the bill requires the Secretary of State and Judicial Council to transfer the data to us that we would then put into DROP. And this would create new security vulnerabilities at each step of the process. So staff has suggested amendments with a couple of suggestions, options. One would be having the Secretary of State and Judicial Council notify the relevant officials to create their own DROP account, or have the Judicial Council and the Secretary of State create a DROP request with a minimal amount of data, like an email request, and then have the elected official or judge build out the drop request to make it more effective. And finally, the bill still tasks the agency with responsibilities or outside its mandate. Cal Privacy would have to reach out to all elected officials, estimated to be 25,000 people, to verify that they want to be included on the deletion list, to be much more streamlined and intuitive, to have the appropriate entity, such as the Secretary of State, provide a list that only includes folks that want to have drop requests submitted. So for these reasons, we recommend support, if amended, position on this bill.
Board Member Hamer?
Yeah. So assuming that we can get the list that is only the people who want to participate in the drop, can you just help me understand the technical requirements that can't be implemented by 2027? Because wouldn't that just be in our current drop system?
Sure. So I will point out January 1st, 2027, sounds like it's really far away, but we wouldn't know until fall whether or not the bill had been adopted. And then we would have to reconfigure the system to be able to provide a turnaround time for 5 days for the elected officials. So that's what we need resources for.
Board Member Liebert?
We've had great help by this author, so I assume that there's a lot of cooperation in trying to address these issues, obviously. I get a little nervous about the agency being on the hook for mistakes made where somehow the system leads us to put someone in the drop system that doesn't want to be there, for example. So it's good that you're being very sensitive to that. I'm sure there isn't much of a precedent here, right, for an agency like ours being responsible for this kind of process without there being adequate assurances that that particular individual on any long list of 20,000 or whatever definitely wants to have us do this work. Yes?
Correct, yes.
Thank you.
Okay, moving to the next bill that we recommend the board consider a position on, AB 1542 from Assemblymember Ward. In staff's view, this bill meaningfully advances consumer privacy by strengthening privacy protections with respect to sensitive personal information under the CCPA, specifically by prohibiting the sale or sharing of such data. So again, the board has previously taken a position on similar bills last year, like AB 1355 and AB 322, that sought to increase protections for location data by prohibiting its sale, among other things. So we think this bill is important. Sensitive data is deserving of heightened protections. The sale of this data related to health conditions, race, immigration status can lead to discrimination and harassment. Similarly, disclosures of personal identifiers and financial data can cause identity theft and fraud. So limiting both the sale and sharing of sensitive personal information would provide protection against significant risks of fraud, discrimination, and even extortion or blackmail that can occur from the widespread circulation of this data. Additionally, this bill would enable California to keep pace with Maryland, which has recently enacted a privacy law that prohibits the sale of all sensitive personal information, and other states that have prohibited the sale of geolocation data. So this bill is also passed Assembly Privacy and it's in appropriations.
Board Member Ozer?
Can you just remind us of what is the definition of sensitive personal information?
It's in the memo.
Okay.
Sensitive personal information is among other things, a subset of personal information that includes, among other things, social security numbers, precise geolocation information, citizenship or immigration status, genetic data, and the contents of messages. I think there are a couple of other categories in there as well.
We've got a neural data.
Neural data, yeah.
Goodness. Okay. Do you want me to read it off?
No.
Okay.
I guess just one of my points is the California constitutional right to privacy protects all personal information, and so just sort of creating some dichotomies there. So just wondering sort of where we are with that.
So when we discuss the bills, maybe Board Member Ozer, you can expand on, it sounds like a concern about having different buckets of personal information with different levels of protection?
I just wanted to clarify.
Oh, okay.
Where we were.
All right. I certainly don't mean to put a position in your mouth. I'm just trying to be helpful. So we'll return to this when we have our discussion. Thank you.
Okay. And then finally, we have SB 1106 from Senator Cabaldon, and that one amends the Delete Act. So that would require data brokers to respond to requests to delete in 30 days rather than 45 days. So staff recommends a support position on this bill because the change ensures that consumer requests will be promptly addressed. When a consumer takes affirmative action to request their personal information be deleted, we think businesses should respond quickly to do so. So we think it's reasonable for businesses and respectful of consumers. So this bill actually has passed out of appropriations and is eligible for a vote on the floor of the Senate. So
Thank you, Ms. Mahoney. I just wanted to pause to welcome Mr. McTaggart, who's joining us remotely now. Good morning, Mr. McTaggart.
Thank you, Chair. I apologize for my absence, but I had another commitment, and here I am. So thank you very much.
Wonderful. Thank you. Ms. Mahoney, please go ahead.
And this concludes my presentation.
Oh, goodness. I should have just held on for 10 seconds. All right. So you would like us to discuss positions on 3 bills, as I understand it. AB 883, AB 1542, and SB 1106. All right. So why don't we proceed in order and start with AB 883. And as a reminder, staff recommends a support if amended position on this bill, similar to the position that we took on a similar bill in the past after discussion. And I will open it up. Do board members have comments or questions? No? Okay. It seems pretty similar to the work that we have been doing to understand, this very important goal and how the agency can reasonably and meaningfully be helpful within the bounds of our capabilities, but also what is a sort of appropriate work for the agency. So I hope that we can all continue to work together with the legislature to help address this important issue of personal data for state officials. So I will propose motions to cover this after we finish discussing the bills. The next one is AB 1542, which is the sensitive personal information bill that would amend the CCPA to prohibit sale or sharing of sensitive personal information to third parties. And Ms. Ozer had a question about it. Is there further comments or questions on this bill? All right. And then finally, oh, I'm sorry, Mr. McTaggart. I did watch for your hand.
No, I was late doing that, Chair. All I'll say is I thought it was a really elegant, very precise edit, and I'm a big supporter of it. So thanks.
Thank you, Mr. McTaggart.
I have one other comment.
Yes, Ms. Ozer.
Just, given sort of the computing power and sort of the world that we're now living in, many forms of personal information can become sensitive. And so, just very cognizant of that, and a lot of important research that's been recently published on this issue.
Thank you, Board Member Ozer. Board Member Liebert? Oh, your microphone is green, so I read too much into that, I suppose.
And then can I mention
Yes,
one
please.
thing that Mr. Laird reminded me of? So one aspect of the CCPA is that it explicitly authorizes the agency to expand the categories of sensitive personal information by regulation. So welcome continued feedback from the board on that.
Thank you both. We also have SB 1106 from Senator Cabaldon in front of us, and that's the one that changes the access requirements for data brokers from 45 days to 30 days. Comments or questions on that bill? Yes, Ms. Hamer.
We make it 5 days, so everybody's on the same page.
I will say that New Jersey has 10 days for their.
Sure.
There is 10. Yes, Mr. McTaggart, I do see your hand this time.
All I'll say is I always find it ironic that they say it takes so long to stop selling your information, yet literally within fractions of a second of you landing on a page or seeing an ad, your information has been auctioned and someone's bought it. So I think 30 days is eminently doable.
Thank you, Mr. McTaggart. I quite agree. All right. So please feel free to chime in if additional thoughts occur. But thank you, Ms. Mahoney, for a very comprehensive presentation and very clear memos, which I think the reason we aren't asking you a ton of questions is because you have briefed us so very effectively. So thank you to you and all of the staff in the Public Policy and Legislation Division. So I will open it up for public comment in a moment. I will first request motions in line with what staff recommends. So the first would be to authorize agency staff to support AB 1542 and to authorize staff to continue to support AB 1542 as stated, even if amended, if in the staff's discretion, the amendments are consistent with the objectives set out in the memos before us today in our discussion today, and to authorize staff to remove support for or oppose AB 1542 if amended in staff's discretion, it is no longer consistent with the objectives set out today, with the materials for today, or our discussion for today. Secondly, a motion to support SB 1106 and to authorize staff to continue to support SB 1106 as stated, even if amended in the staff's discretion. The amendments are consistent with the objectives set out in the memos distributed to us in our discussion, and to authorize staff to remove support for SB 1106 or oppose it if amended, if in staff's discretion it is no longer consistent with the objectives set out today in the materials for today or our discussion for today. And then finally, to support AB 883 if amended to meet the criteria described in staff's recommendation memo, and to authorize staff to continue with that position, even if the bill is amended, if in staff's discretion the amendments are consistent with actually, let me start over, because if it's amended in the way we would like, then we would like to, I would like to propose that we could authorize you to support or to move to opposition, I suppose, if things went really south, which I don't expect. So let me start that motion over. To authorize agency staff to support AB 883 if amended to meet the criteria described in staff's recommendation memo, and furthermore to authorize staff to support AB 883 if it is amended and in staff's discretion, the amendments fulfill the requirements that we discussed today and set out in the memos before us on AB 883, and to authorize staff to remove support for or oppose AB 883 if amended, if in staff's discretion is no longer consistent with the objectives that we set out today with the materials, our discussion for today. So it's three motions, two that are as similar as I could make them in the moment for AB 1542 and SB 1106 to adopt staff's recommendation that we support these bills, and one for AB 883 that would be support if amended. So now that I have set those out, let's start with SB 1106, and I'll just double check if there's any additional comment on that one. Okay. Yes. AB 1542. Okay. And AB 883. All right. I would. Yes. Mr.
Sure.
McTaggart.
You're the attorney and expert, and I'm not. I noticed that a group I'm affiliated with, California for Consumer Privacy, was a supporter of 883, and just want to know. I mean, I actually think that the amendment request is good, so I think I probably should have put that in my letter. Whatever. What do you want me to do? I could do anything you want here.
Sorry. So, okay. So they've supported the bill. You can recuse yourself from the vote.
Sure.
Okay. All right.
Yep.
So Board Member McTaggart will recuse himself from the vote on AB 1542.
No, 883.
Sorry, 883. I'm sorry. Okay. Let me say for the record the correct information, which is that Board Member McTaggart will recuse himself from the vote for AB 883 should someone propose the motion and I get a second. Mr. Liebert, is your microphone green to speak this time?
Tell me when I can.
Oh, please go ahead. Yep.
Similar to you, Board Member McTaggart, I will be recusing myself from SB 1106 and 1542.
Thank you. Board Member Liebert will recuse himself from the vote for SB 1106 and AB 1542.
Yep.
Okay. All right. Let's ask if there's any public comment on this item.
This is for agenda item number 3, legislative update and authorization of agency positions on pending legislation. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 3. I do have a hand raised. Matt Schwartz, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good morning. My name is Matt Schwartz for the record. I'm a policy analyst at Consumer Reports. Thank you for the opportunity to speak today. Consumer Reports urges the agency to officially support AB 1542, a bill to ban the sale of consumers' sensitive data. This will provide default protections that preserve the privacy, autonomy, and physical safety of all Californians. California's current protections for sensitive data lag behind those in many other states. In order to protect themselves, California consumers must affirmatively opt out or invoke their right to limit sensitive information, a right that few consumers likely even know about, let alone how to exercise. As a result, consumers' sensitive information is regularly sold to hundreds of third parties without their awareness. This has led to a number of harmful downstream uses of this data. In recent years, for example, car companies have been caught secretly collecting and selling consumers' location data with insurance companies. Health websites, period trackers, and mental health apps have been caught secretly selling consumers' medical information to social media websites. And data brokers have amassed enormous portfolios of sensitive consumer data that they have failed to protect. The Joint Economic Committee recently reported that 4 recent data broker breaches cost consumers $20 billion alone related to identity theft. In some of these cases, consumers theoretically provided their consent to such uses of their data. But in practice, many companies obtain this consent through Byzantine and confusing privacy policies that hide the ball, or that simply require the consumer to consent to all possible uses of data as a condition of signing up for the service. Despite laws that purport to address this issue, we've had years of evidence that consent is easily gamed and that we need a stronger approach. In fact, this legislation would help California join the movement of states heading in that precise direction. For example, in 2024, Maryland banned the sale of all sensitive information as part of its comprehensive privacy law. Last year, Oregon also banned the sale of certain subsets of sensitive information. And this year, several states have considered similar bans, including in Maine, Massachusetts, and Vermont. Californians deserve this same level of protection. We think that this is a goal worth fighting for and worthy of the agency's time and attention this session. Again, thank you for the opportunity to speak, and we're happy to provide any support for this initiative in any way that we can. Thanks.
Thank you for your comments. Again, this is for agenda item number 3. If you'd like to make a public comment, you can do that by raising your hand using the raised hand feature or by pressing star 9. Madam Chair, I'm not seeing any additional hands raised at this time.
Thank you very much, and thank you for the public comment. With that, I will ask if I may have a motion on AB 883, which was the supportive amended supportive amended position recommended by staff from a member of the board other than Mr. McTaggart. I have a motion from Ms. Hamer. May I have a second?
Second.
Thank you. I have a motion on the table from Ms. Hamer and a second from Ms. Ozer. Ms. Carwile, will you please conduct the roll call vote? And Mr. McTaggart is recusing himself.
This is a roll call for the motion as stated by Chair. Board Member Hamer.
Approve.
Board Member Liebert.
Aye.
Board Member McTaggart.
Recuse myself.
Board Member Ozer.
Aye.
Chair Urban.
Aye.
We have 4 yeses and 1 recusing themselves.
Thank you very much. The motion passes with a vote of 4-0. Let's move on to AB 1542. Thank you, Mr. Liebert, for letting us know you will recuse yourself on that one. May I have a motion from someone other than Mr. Liebert for, as stated before public comment, and that is broadly speaking to authorize staff to support the bill. I have a motion from Ms. Hamer. May I have a second?
Second.
Thank you. I have a second from Mr. McTaggart. Ms. Carwile, would you please conduct the vote?
This is a roll call for the motion as stated by Chair. Board Member Hamer.
Approved.
Board Member Liebert.
Accused?
Board Member McTaggart.
Aye.
Board Member Ozer.
Recuse.
Chair Urban.
Aye.
Madam Chair, you have 3 ayes and 2 recusing themselves.
Thank you very much. The motion carries with a vote of 3-0 with 2 recusals. Thank you very much, the board members, for their recusals. And let's move to SB 1106. Mr. Liebert is recusing himself on this bill. So may I have the motion as stated before the public comment to support this bill from someone other than Mr. Liebert?
So moved.
Thank you. I have a motion from Mr. McTaggart. May I have a second? Thank you. I have a second from Ms. Hamer. Ms. Carwile, will you please conduct the vote?
Board Member Hamer.
Aye.
Board Member Liebert.
Accused?
Board Member McTaggart.
Aye.
Board Member Ozer.
Aye.
Chair Urban.
Aye.
Madam Chair, we have 4 yeses and 1 recusal.
Thank you very much. The motion carries with a vote of 4-0 with 1 recusal. Thanks very much, Ms. Mahoney, and to your staff as well for a typically comprehensive and crystal clear presentation of the complicated legislative landscape around personal information and data, which is complicated because of the incredible importance of the issue. So we appreciate the legislature's attention to these issues, and thank you and your staff very much for your briefing and for identifying bills for us that we should consider for a position. I suggest we take a short break. How much time do folks need? 10 minutes? Sure. All right, 10 minutes. So let's return at 10 to 11. Thank you all very much. Turn to agenda item number 4, which is our annual enforcement update and priorities. It will be presented by Mr. Michael Macco, Deputy Director of Enforcement. And I'll ask you, Mr. Macco, to please go ahead. We do have a slide presentation I'll ask everyone to turn their attention to.
Great, thanks very much. Good morning, Mike Macco, Deputy Director of Enforcement. I was here to present about 6 months ago for the annual enforcement update. Happy to be here today to talk more about the very busy few quarters it's been since we last saw each other at the last meeting. Let's see here. Let's get these slides started. Okay, we got it. So back in September, we talked about really 3 different categories of things for enforcement. The first was what we've heard from consumers, what we're seeing in consumer complaints. The second big category was our evolution, our growth as an enforcement division. And the third was our enforcement activity and our priorities where we sought the board's input. So I'm going to follow the same format. I'll stick with those same categories today to give the board updates on what has transpired since. I'm mindful as well that we have 2 newer board members, so I'll also add some context as I go relating to our enforcement division. And of course, as always, please feel free to interrupt me at any point in time. I know Board Member Liebert, you in particular had a question earlier during the Executive Director update about data brokers. I will turn to that as well when we talk about data brokers, but of course, anything else that comes up, please stop me. So let's start with consumer complaints and where we are now. As the board knows, our law requires us to receive complaints from consumers. It's been a really valuable resource for us as an enforcement division to have to see those complaints and to have access to those. We launched our complaint portal in July of 2023. So it was one of the first infrastructure projects we had as an enforcement division, aside from kind of building out our staff. The portal and the complaints have been a great success for us within enforcement. Through the end of March, so through the end of last month, we've now received 12,546 consumer complaints in total, going back to when we launched the system. So the chart on the screen shows you kind of the steady growth that we've seen and the aggregate growth we've seen in consumer complaints over time. Kind of the rate isn't obvious from this chart, but it's if you were to compare year over year, we're about a 125% increase in consumer complaints. So in other words, we are seeing the volume of consumer complaints that we have, that's been increasing each year. It hasn't plateaued yet. I do expect at some point it will plateau and we will get more of a predictable number each month, each year. I think we're still in a phase where Californians are learning about their rights. They're becoming more assertive in taking control over their personal information, and that is leading to more awareness of the complaint system and more awareness of those rights. This is no doubt a function of the work of our public affairs team that has been working for the last few years on making public education a priority and on making rights more visible for people. And for us in enforcement, the growth tells us a couple things. Consumers in California care a lot about their privacy. We know this, of course, from Prop 24 that created our agency, but when you look at charts like this and when you see volume like this, it is reaffirming that Californians continue to care a lot about their privacy rights. And second, there's a need for more enforcement. We are likely the largest agency in the United States devoted solely to privacy. But we are a fraction of the size of data protection authorities in certain other countries, even though our population is quite large, sometimes larger than other jurisdictions, and we are the 4th largest economy in the world. So the volume of complaints that we are seeing tells us from an enforcement perspective that there's more we can do. In terms of what the complaints look like, on your screen is a slide from the last meeting just to level set about where we left it and what complaints looked like then. You will see the most common and least common categories of consumer complaints that we're getting. So the right to delete being the most common, followed by complaints about collection, use, storing of personal information, and the right to limit. And on the least common side, right to correct, children's privacy, financial incentive programs. And you'll see that the percentages don't add up to 100% because a single complaint can, and often does, relate to more than one category. Let's look at the updated metrics for consumer complaints. So this shows most common and least common complaints from inception through the end of last month. And you can see that the trends have basically held steady. The breakdown is roughly the same. The percentages haven't meaningfully changed, and the most and least popular categories are, in fact, the same. But if you were to break it down into kind of smaller slices, we do see variability based on quarters. And we look for trends at different points in time. And if you were to look, for example, at Q1 of this year, you will see some slightly different percentages. Although the categories are the same, we had more complaints about the collection, use, storing, and sharing of personal information in the first quarter of this year. That was because there were some large data breaches earlier in the year that received some media attention and that did prompt complaints. In the longer term, our data has been more consistent, and you'll see kind of a smoothing out into the percentages that I shared earlier. So these complaints are...
Can I ask a question about that?
Please.
How noisy is this? If we have a total of 12,000 to 13,000 complaints, and we are looking at any given time, a snapshot of 3 to 6 months, the numbers that we have could mean that the statistics are pretty noisy because you're not going to have a lot of significance. Is it noisy like that, or do you feel confident that these are solid trends?
There are solid trends in terms of those, the most common and least common categories,
Sure, yeah.
By and large, being pretty consistent, even month over month. You do see a lot of noise in terms of the specific issues. You do see occasional blips where you will have one particular issue dominate. For example, a data breach.
A data breach. Okay, thank you. Have you seen any? Well, you know what? I will withdraw the question. I think you answered it. Thank you.
So for us, well, look, when we look at this data, it's pretty affirming to us about the priorities that we've sketched out for enforcement. We know that consumers care a lot about how businesses are collecting and using their personal information. The right to opt out is obviously central to that. It's central to how businesses share our information. We have made that a priority through our enforcement activity from the start. More on that shortly. The next kind of broad category for today, something that I touched upon in September, involves our enforcement team overall and the growth that we've seen. We built our enforcement team similar to how I used to staff fraud cases. So as some on the board know, I was a prosecutor at the Department of Justice and a trial attorney at the SEC before I came to the agency. And when you're building a fraud case in those contexts, the way you do it is you typically have one attorney or more. On the legal side, you have an agent, a federal agent, kind of doing the factual investigation with you, partnering with you, but they're doing the factual development. And then you have legal support professionals kind of supporting both. And that's a common team in a lot of different kind of cases and a lot of different prosecutions. We have built our enforcement division and we staff our cases in a similar way, but we've made it unique to privacy. So instead of federal agents out there in the field gathering facts, we have research technologists who perform that role for us. So research technologists hold PhDs in computer science and related fields, and they're analyzing privacy practices, looking at data flows, identifying potential privacy violations, collaborating closely with the others on the team to find violations. And some of these violations that we see might be easier to spot or more transparent. A lot of other privacy violations can be highly technical and difficult to identify and prove. So our technologists are building the evidence, advising attorneys on the facts, and they serve as really critical partners on our cases. One of our early priorities in enforcement, besides building out that complaint system, was staffing up in enforcement. So we have staffed deliberately. We filled all of our positions within enforcement. The research technologists have been a particular area of growth for us. We, in addition to kind of the full-time team that we have, we've partnered with California universities to hire part-time technologists. So they supplement and serve as important partners for our team on the evidentiary side. And through these university collaborations, we're able to work with folks who are usually far along in their dissertations, enrolled in PhD programs, and have been a really wonderful addition to the team. We do expect additional growth within the enforcement division. The governor's budget proposes funding for 5 additional attorney positions and 1 additional legal support professional.
Thank you. I think Mr. Liebert has a question.
I want to just turn back for a second, Mike, about just the tremendous growth in complaints that your chart showed. And I'm struggling to imagine how you're dealing with that with a relatively small enforcement staff. It seems like it would be pretty overwhelming. And how is that process working when you have this many thousands of complaints that are coming in?
Well, the large number, the high volume of complaints to us means that if we have more staff, there's definitely more we can do. So we have to be really strategic and look for the most impactful investigations to pursue, the most promising. So it results in a lot of hard decisions, but it doesn't mean that we sacrifice anything at all on an individual case basis. What I mean by that is when we pursue a matter, when we conduct an investigation, we do have the resources to handle that appropriately and to pursue it to the fullest extent that we can. But the staffing levels do present concerns for us in terms of the number of those matters that we can do at any given time. And that's important.
So if I'm a consumer and I make a complaint, you're going to get back to me to acknowledge that complaint. But as to what else happens, that's where the metal hits the road, right?
That's correct. We do respond to consumer complaints consistent with our law, and it takes a lot of resources to do that. But on top of that, many consumer complaints can spawn lengthy investigations that are extremely resource intensive. And that's appropriate to get into the technical details of any given privacy violation or possible violation, but it does take a lot of resources.
Thank you. Mr. McTaggart also has a question. If I may follow up on Mr. Liebert's, my guess is that from the complaint system, you've given us sort of the broad trends. My guess is that you also see trends that are more specific than you could share with us here that would help you make those choices about what cases to take so that you can kind of help broader range of consumers without necessarily having a full investigation on every single one.
You're hitting it right on the head, Chairman. Yes, when you get into the data more specifically, or when you look at individual companies or types of practices, we are absolutely looking for those kinds of trends, looking for themes, looking for ideas that would support the types of general priorities that we've talked about.
Thank you. Mr. McTaggart?
Yeah, thanks. Mr. Macco, I'm just wondering, is this an area where you've considered using any of the AI platforms just to kind of, you have thousands and thousands of complaints. You have an understaffed agency by definition. I would just think that maybe just to kind of go through and assess, okay, this one's got merit, this one really we can't do much about, this one's not even about privacy, that kind of thing. Have you been using that at all or thought about using it?
We have thought about that, and there have been initiatives more recently at the state level that authorize the use of different products internally and in a secure way, in an appropriate way. And we're talking with our IT professionals about ways of doing that. We do contemplate improvements to the complaint system for efficiency gains, both improvements we can make without a procurement and without the need to bring in something new, and improvements that may require a procurement and something new. So I do think this is an area that will evolve for us over the coming years, kind of in our processing of consumer complaints. I do expect it will become more efficient over time.
Thank you. Please go ahead.
So the growth that I'm describing that we're talking about in consumer complaints and in our team, I should mention that it isn't limited to Cal Privacy, that this is actually a trend that we're seeing nationwide. States across the country have been enacting comprehensive consumer privacy laws. They've been increasing their own staffs with technologists and with attorneys. We regularly collaborate with those states through the Consortium of Privacy Regulators. And we're just seeing that growth across the board. And I want to credit the other states for working with us in that way and for experiencing the same kind of growth that isn't unique to us. Relatedly, we've seen a growth in enforcement actions. So not only do we have complaints, we have teams growing, we have states that are growing, and we have more enforcement activity. So the first CCPA enforcement case, as the board knows, was in 2022, the Sephora case. That was before we had our enforcement authority. And since then, CCPA enforcement has grown significantly, and it's continuing to grow behind the scenes. So publicly, there are now a dozen CCPA enforcement actions between our agency and the California Attorney General. And of course, we share enforcement jurisdiction with the Attorney General, and the Attorney General's office is an important partner for us. On top of those actions, we've brought nearly a dozen additional enforcement actions against data brokers under the Delete Act. Our agency alone has brought 6 enforcement actions just since the September meeting. That's about 1 a month on average if you were to spread them out evenly, and it doesn't include the Attorney General's additional actions. Since I presented to the board in September, we've brought enforcement actions against Ford Motor Company. That was in just last month, one of the connected vehicle manufacturers. In the same month, we brought an enforcement action against Play On Sports. That was a digital ticketing platform for youth sporting events and other types of youth events. In January of this year, we brought an action against Data Masters, a data broker that was selling lists of people with Alzheimer's disease, seniors, lists of people based on their political views. We brought an action that month against S&P Global, another data broker that had not registered. The month before that, we brought an action against ROR Partners. That's a Nevada marketing firm that catered to fitness brands, and it was selling custom audiences, building custom audiences, and it was not registered as a data broker. And then in September, we brought an action against Tractor Supply Company. That is the nation's largest rural lifestyle retailer. It's a Fortune 500 company. And the fine amount there was $1.35 million. On top of those enforcement actions, we've issued 3 enforcement advisories, the most recent of which was in December of 2025. And on the topic of this growth in enforcement actions, the bipartisan consortium of privacy regulators has also continued to grow and include additional agencies. So there are some themes, or I guess through lines, if you were to look at this enforcement activity in the aggregate and consider what we've been up to over the last even 6 months. So the first is that in multiple previous board meetings, we have discussed how the Enforcement Division intended to prioritize cases that would advance the breadth and scope of the law. We've spoken about the importance of building a corpus of cases, a corpus of board decisions under different topics, under different aspects of the law. And we've done that by intentionally focusing on various parts of the law and on different types of industries, different types of businesses. So from just the list that I mentioned in the last of cases from the last 6 months, you can see kind of a wide variety of industries, a wide variety of different types of businesses. So we haven't limited our enforcement to any one industry or what some might consider to be just big tech. We've intentionally gone broader. And you'll also see, if you're looking for through lines from the cases so far, that we have been following through on the proposal that we had a few years ago to focus on the implementation of privacy rights. Looking more broadly for a moment at actions over time, there have been the cases involving Honda, Todd Snyder, Ford, Play on Sports, Tractor Supply. There may even be others. All of these cases have involved, at least in part, a failure to implement privacy rights or a failure to implement those rights correctly. And you'll also see, in terms of themes, a focus on opt-out rights. Opting out, as the board knows, is a real innovation in California, but it was also a bit of a compromise. If we're going to have an opt-out regime, the trade-off was that it needs to be easy. So we have brought multiple cases for the board's consideration that involved opt-out mechanisms that were not easy. And we've said from the beginning that we would be focusing on opt-out rights. We continue to do so, and we plan to continue doing so. And finally, you'll see, in terms of themes, a focus on data brokers and the data broker industry. It's getting me to a question from Board Member Liebert. We launched a data broker enforcement strike force in the fall, so a focused initiative to tackle issues in the data broker industry. We are continuing to engage with data brokers about compliance with the DELETE Act, and we know that data brokers are an important component of the privacy ecosystem, and that's something that we are considering. Board Member Liebert asked about having seen reports or discussions about there being thousands of data brokers out there. I want to pause here and just address that question head on that came up at the beginning. First of all, I want to validate the concern that consumers have, and that perhaps even the board shares, about the special risks attendant to the data broker industry and data brokers. We've seen this, of course, play out in multiple data breaches, and we know the sensitivity of the role that data brokers play in the industry. We want to bring actions to give consumers more visibility into that and more control over how that industry operates as it affects them. We have brought a number of cases against data brokers to make sure that the registry reflects all data brokers who are operating here and who meet the definition of data broker under California law. There are currently 577 registered data brokers in our registry. If you look at the enforcement activity we've taken over the last few years, and you look at the trajectory of data broker registrants, the number has increased every year. I don't think that's a coincidence. I think it's a product of the fact that we have been diligent about pursuing unregistered data brokers. As for sometimes the reports that you'll see in the public domain about thousands of data brokers, there may indeed be thousands of data brokers, lowercase data brokers. The question for us is, from an enforcement perspective, which of them are data brokers under California law and under our definition? And that is more nuanced. I think the real number of data brokers under California law is somewhere between the number that is currently registered and the number that's maybe operating in a more generic sense. As for where exactly that number is, that's something we are working to identify through our investigations. We have a lot of investigations going on right now against potential data brokers, involving potential data brokers, to try to make sure that we close any gap. There shouldn't be a gap between the registry and the number of data brokers who qualify under California law. I don't think the public reports about data brokers in the generic sense, it reflects or is necessarily the number that is for California. But I also am not convinced that we have all of the data brokers in the registry who should be registered. And so we're looking to see what that gap really is. I don't have the answer to it yet, except that that's where we're spending a lot of our time right now is on those kinds of investigations. So I'll pause there to see if there are any follow-up questions on that, since we were talking about it earlier.
Well, first of all, thank you for that explanation. And obviously, getting that factor correct is so helpful to the overall functioning of the DELETE Act, right? Because when I, as a consumer, am saying I want to, have my data back, we got to make sure that we're collecting it as broadly as possible. So, so I'm glad that that's the focus that you have. That's great to hear. Thank you.
Yeah, it doesn't work if not all data brokers are registered. Moving on to investigations, we are in the middle of continuing to advance all of these priorities and themes through the ongoing investigations within the Enforcement Division. Most of our time within enforcement is spent in this investigative process. It's a really time-consuming and kind of resource-intensive part of what we do, but it is important. We spend most of our time engaging with businesses, gathering the facts. Our goal is fairness, and it's getting to the right result. And the goal is to bring cases when we think that there's been a violation, and to make sure that we are engaging with businesses to get to the right answers, not rushing to judgment, but at the same time, bringing actions as efficiently as possible. I was happy to hear earlier today Chair Urban's comment about her favorite provision in the CCPA, which relates to collaboration with other jurisdictions and kind of the law's mandate.
One of my favorites.
One of.
I have many favorite children. Oh, I guess they're Mr. McTaggart's children. I'm fond of them as well.
Well, we will. I will confess that the collaboration provision is one of enforcement's favorites as well, and it really does give us the mandate to do collaborative work with with partners in other states and other jurisdictions. This is an area that I mention in particular because it's been an area of special growth over even the past 6 months and over the past year. We propose to continue devoting energy to fostering the relationships that we have with other states. The goal for us is for those collaborations to show up in public enforcement actions at appropriate times. But for now, I can say that the collaboration between states, between us and other enforcement authorities is very much underway in a manner consistent with that statutory provision. Collaboration with the newly created audits division is something I think we'll see. It's already started, but it's something we will see more of over the coming year. I'm especially excited about the audits division because of how I used to work with auditors in other roles and how I have seen other agencies successfully have a collaboration between an audit function and an enforcement function. There's a lot of precedent out there for that kind of parallel and collaborative work. And I'm really excited about building that out on the enforcement side. And I think those functions will complement each other well. And lastly, with the drop requirements that are going into effect this fall, we do expect to devote significant enforcement resources to look for potential violations. Data brokers will need to be deleting the personal information of Californians who request deletion through drop. We do expect to spend considerable time on those investigations. With that, I am grateful to the board for the opportunity to provide these updates, and I'm happy to answer any additional questions.
Thank you very much, Mr. Macko, and thank you to your whole team for all of the really effective, thoughtful, strategic, and high-quality work that it has been doing. I know that, as with every division, my guess is that sometimes it's been pretty intense. And so our thanks to you on behalf of the people of California. Comments, questions? Okay, Mr. Liebert.
I've been so impressed with what your division has been able to do these past couple of years that I've been here. And to say punching above your weight is an understatement. So I just want to congratulate you in that regard. And it strikes me how important the enforcement process is when consumers don't have a private right of action to protect themselves in that regard. So they're really depending upon our agency to do that for them. And I just found your presentation really encouraging as to how we're working this through. So thank you very much.
Thank you.
Thank you, Mr. Liebert. Board Member Hamer?
I echo those comments as well. You're doing a great job with the shoestring staff. So thank you. How do you go about finding data brokers that aren't complying, that aren't registered, that should be registered?
I'm
Without revealing investigative techniques.
Okay.
How did you know the disclaimer that was coming? Yes, exactly. I was trying to think of a way to answer that without doing exactly what Chair Urban said.
You can abstain if you need to.
But I can answer. It's look, we have between the attorneys on the team, the research technologists, and our legal support staff, we look at a variety of different sources and in collaboration with other states, try to find any gap. And there's a lot that goes into that, and it's not easy. And what you might assume at the outset is something that may appear to be, for example, a data broker, might, when you get deeper into it, not be. And that's not a failure at all of the enforcement process. That's a feature. You want to be able to make those determinations efficiently and correctly. You don't want to bring cases and spend significant time on investigations where it's not warranted. And that's our challenge, is to strike that balance. But I would underscore that it's not an easy process, but it is a necessary one for us.
Oh, of course. And then one other follow-up at the audits division, I know is pretty new, but prioritization, how are you deciding where to focus there?
On the audits division, I would defer to our Chief Privacy Auditor, Sabrina Ross, on those aspects. I can tell you from the enforcement side of it, though, a priority for us is making sure that we are supporting the audits division in any way we can as it builds its own infrastructure in the same way that we have done on the enforcement side. There are certainly lessons we've learned from enforcement that we want to share with audits, and a priority for us will be making sure we're providing that support as audits grows and as audits shares more of its priorities.
Thank you.
Thank you. Board Member McTaggart.
Thank you, Chair. Mr. Mecco, could you just elaborate? I think I brought this up before, but where do we stand on our thinking or in practice? You know, my dream is that every website that I show up on, it's super clear within the first kind of landing page that either they're not selling and sharing my information, or there's somewhere I can click and say, don't sell or share my information. And ideally, my browser is set to, don't sell or share, and it just acknowledges somehow to me that we're not. Or if I go to the privacy policy, it's obvious. And I'm always surprised, by going, we never have the time, but you go to the privacy policy, you can't tell immediately, or worse, it says, here's the link to the advertiser, the Google kind of master thing, and this is their practice. It's not our fault, whatever. It's just always still very opaque to me. And then every once in a while I get to a website that's just clearly, either we don't sell or share, or here's the TCPA opt-out. What's your thinking about just a mass kind of like, hey, here's what's going to happen, and people who are not compliant with this are going to get dinged a certain amount of money. Here's a template you must adhere to. I just feel like it must be, and like you want to also be doing these big things you've been doing so well with these actions against data brokers or against retailers that aren't complying, and congratulations to you on that. But I also think that this mass kind of approach to trying to say to people who do business in California, hey, this is the law, and you can't just not be clear about it. What's your thinking there? And sorry for the long, complicated question. Not complicated, but just not well said.
Given the staff that we have, our strategy for tackling that issue is to look for the most impactful ways of getting at that problem. Another approach might be if we had more resources, or certainly if we had unlimited resources, we could go after all of those problems and have a huge impact. We know that that's not feasible for a lot of ways. And so the way we've approached it is trying to identify cases that we can pursue that present common problems along the lines that you're describing, and pursue them. It doesn't mean that if we do multiple enforcement actions, for example, over opt-out implementation or failure to offer an opt-out, that it's going to solve the problem everywhere. I do think it reduces the number of violations, and it does bring businesses into compliance when they see that the agency has taken that requirement seriously and brings actions. But in terms of like a larger scale effort to do it, we are still being strategic about which of those cases we can bring and which ones we have capacity to do.
Just on that though, on that point, I guess I would just urge you to maybe consider an and approach, because think about like when we all had to get real IDs, right? And then you saw flying in an airport that you weren't going to be able to use your old ID, and eventually the pain point was going to be that you couldn't go through the TSA anymore. To the extent that we were kind of loud about saying, okay, this is we're going to get serious about this particular thing. I mean, this strikes me as an area that is absolutely perfect for AI, right? You set up the agents and say, just go through these websites and tell me which ones are not compliant. And you send them a letter and you say, you have 60 days to get in compliance. We're going to do this again, and then it's going to be X thousand dollars a day. That could be. I mean, I just wonder if that's also not a wise use of the resources, because I think with AI, some of the stuff is now it's really pretty extraordinary what we can achieve at scale.
Yeah, an AI tool can get you so far with that kind of analysis. The second step is then, of course, is a business actually selling or sharing information such that those requirements are triggered in the first place, which then requires additional layers. So where an AI tool may theoretically can be useful in that approach is giving you some universe from which to draw from. We have a lot of technical tools at our disposal that give us a universe and that help us with that, but we're taking some other steps on top of that to go deeper. And for us, it's not as simple as finding all sites that don't have that link, let's say, because there's often more to the story. So that's just a complication, remember, McTaggart, for us, but it is not at all diminishing your point about we should consider which tools are available and how we can develop more tools to identify more violations. That's absolutely something we're doing on the technologist side and what our technologist team has been working to build. So I'm with you there, and I know the whole team has been. We spend a lot of time in our own meetings talking about ways of finding violations more effectively, more efficiently, and at a broader scale to have impact. So
yeah, I think I'm almost more saying it's ones where they condemn themselves, right? Their own website is not just forget what they actually do. Their website's not in compliance. That's the kind of thing I'm thinking that's the easy, low-hanging fruit. And I feel like there's a lot of them where they do kind of prevaricate and they sort of they hem and they haw on their websites, and you're like, well, are you or aren't you? And so and they say we may sell, stuff like that. So I don't know. I think it's really important what you're doing. So I don't want to, please don't take this as criticism. The sort of the big game hunting, so to speak, of the bigger entities. But I also think that there could be a parallel and very complementary effort to try to just clean up on the low-hanging fruit, the tens and millions of entities that do business in California that are not just overtly not compliant with the law.
Thank you, Mr. McTaggart. Ms. Hamer?
So I echo Mr. McTaggart's concerns just in logistics to come to this meeting and even ordering lunch. The websites that say by continuing to use this website, you're agreeing to our privacy policy. That's a low-hanging fruit. And I know toward the beginning of enforcement, there were some letters from the AG's office that said, we're looking at this, you guys take a look at your own house and clean it up. That's not what they're doing with the information, but when I see that, I'm like, that like blatant violation. So that probably can be handled with limited resources, even if there's just some sort of enforcement heads up, you guys, we're going to take a look at this stuff, because it's pretty easy to just go on the websites and say, okay, this one's not in compliance. And no, I don't want to read your privacy policy right now because I'm driving and I have to find you, that kind of thing.
Great. We do occasionally, as the board knows, announce investigative sweeps in different topics. And so we'll certainly take all of this feedback into account as we think about an appropriate way of doing the next effort like that.
Yes, Ms. Ozer.
I just want to commend you all for the work that you are doing. And also to note, it didn't seem to be on the sort of how the team is spending its time, but I am also seeing you all quite out and about at events where you are talking to the legal community or talking to the business community, so that there are also people who are advising those companies, to sort of be able to increase the reach of, the responsibilities and the requirements of the law. So I just did want to also commend that is happening and how important that is as well.
Thank you for that feedback. That, in our earlier days, it was was harder for us to do as much of that as we probably should have, as we had to build out early infrastructure. We have more recently tried to do that more intentionally because we have the public affairs, public education component of our mandate, and that is a complementary function with our public affairs division. But from an enforcement perspective, we realize that that is useful, and it helps hopefully reduce the number of violations that we see the more that the industry knows what we've been focusing on. So thank you for that.
Thank you, Ms. Ozer. I want to pick up on a number of things that have been said and echo them. I just really want to commend you again, as I have in previous meetings, but with more detail behind it as you continue to develop, for your broad approach to helping businesses understand their obligations through enforcement actions that educate them on how the law should be interpreted, through the public outreach that Ms. Ozer mentioned, and through the public advisories as well. All of those components are really important, and I'm incredibly excited to hear more about the consortium of states, because that's another way, of course, to build out that knowledge base that companies need in order to understand most effectively and efficiently how they can comply with the law. Accountability is crucially important. As we know, it's also really important for us to provide information for those good faith businesses, of which there are many who would like to comply. And I think that's one of the ways that you get the most privacy, which is, the most reasonable privacy for Californians, which I think is always our ultimate goal. And so I really commend the team for that. I'm hesitant at the idea of sending agents out because just like I don't want them to make decisions about people without us thinking this through, I wouldn't necessarily want them to make decisions about businesses. But I don't think that's what Mr. McTaggart was saying, but I appreciate the team's apparent really thoughtful approach to developing and exploring tools that can be used to broaden the scope as much as possible without, of course, drawing dolphins into the net. So thank you very much for that. And I guess my question beyond the comment is there anything that you would request of the board?
No requests except to express appreciation for the board's support for our work and support for our plans for continued growth as a division.
Okay. Is there public comment on this item, Ms. Carwell?
This is for agenda item number 4, annual enforcement update and priorities. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 4. Madam Chair, I'm not seeing any hands raised at this time.
Thank you, Ms. Carwell. Thank you again, Mr. Macco, and everyone for the engagement with this topic. Now, you had a bit of a smaller window between your annual updates this time because we did have a lot to do with rulemaking last year. So we will look forward to seeing you for next year's update. This is the regularly scheduled one, I believe. And of course, we will welcome you back anytime that you have something you wish to share with us or need us to make a decision on.
Thank you very much.
All right, thank you. With that, we will move to agenda item number 5, which is a review of adequacy requirements with the European Union and the existing EU-US adequacy decision by the European Commission. It will be presented by Deputy Director of Policy and Legislation, Maureen Mahoney, and our General Counsel, Philip Laird. And I think we're all quite interested to hear about this. It's been on our upcoming potential future agenda items for a while, just to learn more about the possibilities here. And so we look forward to hearing from you. There are some materials in your packet. Please do turn your attention to those. And Ms. Mahoney or Mr. Laird, please go ahead.
So we'll be splitting up this presentation. I'm going first. So thank you, Chairperson Urban and board members. We know that the board has been interested in learning more about whether California may legally obtain its own adequacy decision under the European Privacy Law, the GDPR, to facilitate cross-border data flows from the European Union, which I'll refer to as the EU, to California. So staff has explored this issue through meetings with the European Commission and a detailed legal analysis by Phil's team. And we're pleased to share some information about the adequacy process, the current lay of the land regarding data transfers between California and the EU, and an initial analysis of the potential for a California adequacy decision. So first, what is an adequacy decision? So it's a determination from the European Commission, which is the executive arm of the EU, that a country outside of the EU or a sector within that country or territory or an international organization offers an adequate level of data protection. So this enables personal information to lawfully flow from the EU to that non-EU organization without further safeguards. And we'll get more into those safeguards and why that's important in a minute. To obtain an adequacy decision, a non-EU organization must be able to demonstrate that the level of data protection is essentially equivalent to that guaranteed in the EU. The non-EU organization must meet certain substantive requirements. Those are demonstrate adequate content principles such as transparency, rights to access, rectify, and delete, restrictions on onward transfers, have procedural and enforcement mechanisms such as an independent supervisory authority to enforce compliance with privacy requirements, and provide essential guarantees limiting access to personal data for law enforcement and national security purposes. So specifically, the non-EU organization must ensure that personal data processing is based on clear, precise, accessible rules, is necessary and proportionate to the legitimate objective pursued, is subject to independent oversight, and that effective remedies are available to individuals. So this brings us back to the question of why adequacy is important. So an adequacy decision is particularly valuable because the alternatives for data transfers without one require substantial time and resources. Without an adequacy decision, organizations must rely on other methods to lawfully transfer data, such as standard contractual clauses or binding corporate rules. Binding corporate rules are typically used by multinational corporations. They're legally binding data protection policies that govern the transfer of information, within organizations. Standard contractual clauses are one-to-one or multi-party agreements that govern the transfer of personal information outside the EU between those parties. So these can require pre-approval of the European Commission or the lead EU data protection authority, completing a transfer impact assessment, and notification to EU partners when public authorities access data. There currently is an adequacy decision in place that facilitates the flow of personal information between the EU and the US, and that's been in place since 2023. It relies on the EU-US Data Privacy Framework. So this is a voluntary framework that 3,500 US-based organizations have opted to participate into as of March 2026. These organizations must publicly commit to the framework and annually self-certify that they meet its requirements. And these public commitments serve as a basis for enforcement. For example, the Federal Trade Commission could take action if the company fails to live up to its public commitments. Adequacy decision also explicitly relies upon Executive Order 14086 and Department of Justice regulations that were issued pursuant to that executive order. So together, the executive order and the regulations address deficiencies that were found in previous EU-US frameworks. Specifically, an EU court found previously that there were insufficient limits on the federal government's collection and use of personal information for national security purposes, and a lack of effective remedy for EU citizens whose data was transferred. So in response, this current framework restricts, through the executive order, US intelligence activities to what's necessary and proportionate, subjects those activities to oversight, and the regulations establish an independent and binding mechanism that includes the Data Protection Review Court through which EU residents can seek redress. Adequacy decision that's in place now has been subject to challenge brought by a French member of parliament. That's still pending. In addition, another privacy advocate, Max Schrems, has also suggested he may challenge the decision, as he has previously for previous agreements. Those who question the adequacy decision commonly point to its reliance on an executive order that can be rescinded at any time, and an alleged lack of independence regarding the Data Protection Review Court that the data privacy framework relies upon.
I'll give Ms. Mahoney a break. Turning now to consider pursuing a potential California EU adequacy decision. So in staff's view, with the existing US-EU adequacy decision in place, a separate California EU decision would provide no additional or immediate legal benefit. California businesses already enjoy the benefits of adequacy and can transfer data from the EU to the US under the existing US-EU framework. However, if the US adequacy decision were to be invalidated due to the vulnerabilities previously mentioned, US businesses would need to find alternative ways to transfer data, raising the question of whether a California EU decision could fill that need. However, if the EU-US decision were invalidated, it would most likely be due to concerns about the federal government's collection and use of personal information, which we heard a lot about yesterday. California would be unable to address some of those concerns because, as was alluded to in the presentations yesterday, the supremacy of the US Constitution and federal law prevent California from limiting the federal government's processing of personal information for law enforcement or national security purposes. Additionally, there are some differences between California law and the GDPR that could make an adequacy decision challenging, including the fact that CCPA generally only applies to for-profit businesses and not government or nonprofit entities. So at a foundational level, the risk that California and California businesses will ultimately be required to provide personal information to the federal government, despite California's objections, is a vulnerability outside of the state's control that could impede an adequacy decision. So in conclusion, at the moment, it does not appear that an adequacy decision between the EU and California would have any impact on our existing circumstances, since California does enjoy the benefits of the decision currently. If that were to change, however, it is not clear that California would meet the EC's requirements given the supremacy of federal law. And in any case, pursuing an adequacy decision for California will likely require significant time and resources, not just from agency staff, but close coordination and work amongst other state stakeholders, such as the governor and the legislature. So with that all in mind, staff today recommends that the agency remain in a monitoring posture with respect to this topic and reevaluate the need and interest to pursue an adequacy decision for California if the existing EU-US decision is overturned in the future. That concludes our presentation, and at this time, we're happy to turn it to the board for discussion and any questions you may have.
Thank you very much, Mr. Laird. Comments or questions from the board? Mr. McTaggart?
Yeah, thanks for that. I mean, it's always been apparent to me that, California was not going to be able to just kind of waltz in and get adequacy. But I've also always been intrigued that GDPR explicitly says not just countries, but territories. And what I've always thought of the benefit of trying to start the adequacy discussion has been sort of self-preservation. We keep on seeing these efforts, and I know that Ms. Mahoney and Director Kemp have been very involved in trying to head off attempts at preemption in DC recently, and that's going to be a constant battle. As the more effective we become, the more the tech industry tries to get rid of us by doing an end around up in DC. And so I think, I've always thought that if we could start the work and just get a sense of what has to be changed, and of course it would have to be a sort of a hybrid adequacy where it would be like, hey, for-profit entity, because we don't cover nonprofits yet, we don't cover the government, but hey, for-profit entity, here's how, if you comply with California's law here and whatever, then, and if you subject yourself to California's regime, then you'll be adequate. First of all, that's a huge incentive for companies around the United States would be a huge incentive for them to adhere to our standards. It would help make our standards more universal, sort of the same way the EPA, the Cal standards became for a while there, the standards for the country. And this administration won't last forever. Now, who knows? The next one may come in more hostile but at the same time, I feel like certainly this isn't something where we can just go and say, expect within 6 months to have negotiated it. But I think it would be useful to start the discussion with the regulators in the EU, just to sort of get a sense of what's missing, because it was always apparent to me that they were going to come back with a laundry list of things and say, well, forget the nonprofit stuff. There's going to be these other things within business. And so we would need to know, okay, what do we need to go to the legislature in Sacramento and say it needs to be changed? And this is a longer process, not a shorter process. And so without devoting a tremendous amount of staff time, I think at a high level, whether it's the director or the chair or someone meeting someone in Europe and sort of starting the discussion of what's lacking for us, I just think that would be useful, because who knows when we're going to need to, hope that we have it.
Thank you, Mr. McTaggart. Comments from Mr. Laird or Ms. Mahoney on that thought? To sort of more if I can restate what I thought I heard your proposal to be, Mr. McTaggart, to be sure that I have it right, it would be to explore with the European officials where California law has gaps. We do understand the issue with the national security supremacy. We understand the issue with the fact that our law extends to commercial entities. And then within that more limited landscape, what things might we be able to change?
Exactly. And Chair, it would almost be like the way the standard contractual clauses, which I don't think anybody loves, but if we became a version of that, and the company adopting said we comply with CCPA, and therefore we're good to go. And we all understand that we have a constitution here which preempts our state, the federal preemption. So, but I just don't know. Are we describing a world? I mean, it may come back that there's no possibility, and it may come back that these 5 things need to be changed, which are possible. I just think unless we start the conversation, which by definition is going to be longer than we expect it to be, we're missing a potential opportunity here to bring California onto par with the rest of the world, which would be tremendously beneficial for our regime and for the state, I think.
Thank you.
Sure, I think that's really helpful feedback. Staff has had initial conversations with the European Commission without doing a deep analysis of what might be required for this issue, and identifying a few things. I think a further analysis with the European Commission about what would be required would involve a lot of resources, commitments with multiple stakeholders within California, and potentially within the European Commission. So I think, we wanted to do kind of a deeper analysis of potential benefits of adequacy before engaging in that resource intensive effort. And that's what we're presenting today.
Because I'll just say, I spent a lot of time with the Europeans when I was drafting this to make sure that there weren't any sort of landmines that would trip us up, that would be, okay, that's a never, never. And I'm pretty sure, because I was talking to people who would have made the adequacy decision at the time, and they were like, yep, this is all good. There's nothing that we see here that would prevent it. And so I don't know that we need to have a white paper on the benefits. I think the benefits are somewhat self-evident, that if we had this regime, we'd be the only state in the country to have this. And I get it would be limited. Again, I'm not, I guess maybe I'm oversimplifying, and I could be, but I just think that at the next IAPP or whatever, some kind of a place, if the chair or was going, or if the executive director, but just to authorize them to kind of start that discussion of, or to encourage them to start the discussion of, okay, let's, and they would probably do the work for you and say, okay, here we've looked at your law, here's what's missing. That might be a start. I just think leaving this because it'll be a multi-year process no matter what to get this thing to work. And so I just think, sort of, if you want the tree to be 100 feet tall, when do you plant it? Tomorrow,
Thank you. Mr. Laird?
I think I would just suggest, if going down that approach, the first issue to be discussed would be constitutional issues before we focus further on amendments to California law, because if that's insurmountable, I don't think there would be further discussion on the other components.
Mr. Laird, just remember, we're not doing anything. They make the determination. We don't have to enter into a treaty. It's not, the governor doesn't have to say, okay, it's literally they come along and they deem our regime adequate. It's got nothing to do with an extraterritorial. We just sit there and we have our law. And they've said, yep, it's sort of like the ISO 9000 or whatever.
Ms. Ozer and then Ms. Hamer.
I apologize, because obviously I'm new to the board, so I wasn't here for the conversations that sort of led up to this. But I do want to understand a little bit more what sort of is the foundation of this thinking in terms of what the benefits would be to do this. I understand if the existing adequacy decision did not exist from the US and EU, but are there other things that have been sort of, because that does exist right now. So obviously there could be the threat of it not existing, but I'm trying to understand, are there other benefits that have been surfaced that is sort of motivating this? Because I do hear you about sort of the resources. So I'm just trying to get up to speed.
Could I try to answer that, Chair?
Yes, please go ahead, Mr. McTaggart.
At least from my perspective. So the existing framework, if you keep on, they keep on putting, Scotch tape and string to get this together. And Max Schrems keeps on suing successfully. I think we're on the third iteration now. And so there's a lot of sort of emperor has no clothes kind of arrangement about how we get to protect this, very important ability to transfer data between these entities. There's every reason to expect that this will not be the last iteration. And so I think, okay, you do have the Department of Commerce and the federal government that have these frameworks that keep on getting challenged, keep on getting ruled to be inadequate by EU. And so then we come up with another workaround. It would be great if there was a conversely based in law framework that American companies could just point to and say, we comply with California, therefore we're good. Now, I get that the U.S. government could come along at some point and say, well, now you have to share all your data with the CIA and the FBI. Okay, that makes us inadequate. But at this point, if there were a way where we could become the legal standard and another way of American companies saying, yeah, if we comply with California, the EU has deemed the California regime for for-profit companies adequate, I think that would be a tremendous benefit. And I think most importantly for me, it would be yet another argument when Congress comes after us and tries to preempt, to say, well, you might have businesses saying to Congress, hey, wait a second, maybe don't preempt California because they're doing something useful here. I can comply with them and I can send all my data to the EU and I don't have to worry about it.
Thank you. Ms. Hamer?
So I would love nothing more than a California adequacy situation. I think that, the federal situation's precarious. FISA 702 keeps getting kicked down the road. and it is a Scotch tape situation. However, to Mr. Laird's point, I have trouble envisioning a way around the federal government's authority to issue subpoenas, gag orders and subpoenas to for-profit businesses that are complying with CCPA. So I think that Mr. Laird's point about the constitutional issues really needs to be uncovered before we do a lot of resources in that direction.
Thank you very much, Ms. Hemer. I have a proposal that is going to make nobody happy, which is that I would be happy to take Mr. McTaggart's suggestion that I or Mr. Kemp talk with the European officials to see sort of where their current thinking is, just so that we have some more information about some of the details. I'm unsure that the Commission would find it within their authority or be willing to issue some kind of partial determination. I do take Mr. McTaggart's point that some kind of imprimatur from the European Commission could be valuable. I also am finding the fact of FISA and all of the other sort of intelligence statutes and so forth a little bit difficult to disconnect from the entire question. But if I could propose something that maybe isn't as resource intensive, but does gather more information in the spirit of what Mr. McTaggart is saying, would that make nobody happy but everybody kind of okay? And I'm asking also Mr. Laird and Ms. Mahoney specifically because I absolutely respect the resources issue. And I want to highlight that because the board didn't pick it up yet, that Ms. Mahoney mentioned that we would have to work with a lot of different partners in the state as well. And so I'm not proposing that would be the step, but it would be sort of finding out a little bit more detail. I would be happy to take that on. If, for example, I were to go to the Global Privacy Assembly, that might be a good place to do it, or some other opportunity.
I'll just say no objection from staff.
Okay, thank you.
I
All
wouldn't
right.
say objection. I'd say strong support. I think that's a great idea. I mean, look, things may have changed. It was 5 years ago. They may say, hell no, no way, no how, and they may get a warm reception. So who knows? But I think if we don't talk, we won't know. And so I'm a huge fan of you doing that. That would satisfy me.
Okay, thank you.
I also support information gathering on this.
Okay.
Can't hurt.
Mr. Liebert and Ms. Ozer, do you have strong? Yeah.
Support.
Okay, great. Thank you. Well, with that, I would like to request any public comments on this item.
This is for agenda item number 5, review of adequacy requirements with the European Union and the existing EU-US adequacy decision by the European Commission. If you'd like to make a comment at this time, please use your raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda number 5. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, and thank you to the board for the robust discussion and to staff for doing this very helpful research, which I'm sure it's a novel question and I hope was interesting to the legal division, although I suspect it was quite a bit of work. So thank you for that. We find ourselves at a fork in the road. It is 12:05, and we could take lunch and take up agenda item number 9, which is the closed session item. We could press on and take up agenda items number 6, 7 and 8. Number 6 is the discussion of 7500, which is our conflict of interest code. I anticipate this to be a very administrative discussion. It's just who's covered by the conflict of interest code, and we've grown. And I'm sorry, Mr. Laird, I don't mean to drift outside of this agenda item. And then public comment for items not on the agenda, which will be as long as the public comments are, and a future agenda items discussion, which is usually up to maybe 10 minutes. So do I have views on whether we do one or the other?
My view is understanding that several of our board members have major commutes that I think we should plug on if that's
Okay.
okay.
Yeah. And okay, quick bio break and then continue. Okay, so let's return at 12:15. That will also give us the opportunity to go into closed session, and the public can decide to come back and watch us adjourn or not. So 12:15. Welcome back, everyone. We will proceed with agenda item number 6, which is a discussion and possible action to amend regulation section 7500, which is our conflict of interest code required by California law. It will be presented by Mr. Philip Laird, our general counsel. And you do have some materials in your packet.
Thank you, Chair Urban. As was alluded to earlier, this is a little bit of administrative catch-up for the agency, and a memo was provided in connection with this agenda item today. But in short, the situation is this. When the agency was created, it adopted its first conflict of interest code back in 2021. Since then, there's been significant growth at the agency, which is a very good thing, and a sort of proliferation of different divisions and different functions within the agency. And so it is high time to update and amend our conflict of interest code to really reflect the nature and decision-making of those different divisions and positions, and make sure we have tailored reporting requirements amongst those divisions. So the proposal today before you has been discussed and sort of preliminarily agreed to with the Fair Political Practices Commission. It was brought to my attention that there is a minor edit that we need to make, a single extraneous that, I think in category 2 that we would propose, but that would be sort of for grammatical purposes. But otherwise, the process is that it's sort of like a rulemaking light process. There's a 45-day public comment period, and then we would return to the board one more time for final adoption of these amendments. But with that said, I'm happy to answer any questions, but that's all.
Okay. Thank you very much. Ms. Ozer, was that a hand?
I just have one question. For the new category 3, category 4, and category 5, since I recently filled out these forms as a new member of the board, I just wanted to clarify, would the agency be able to provide us lists of these things? Because as a board member, I may not be aware of anyone who provides media or advertising services to the agency or information technology. I'm just worried about the process of making sure that those of us who are not as close to the actual inside work of the agency make sure we're in compliance.
Yes, great question. So I guess I'll start by saying board members under this proposed amendments would remain in a category 1 disclosure, meaning you'd really be disclosing all interests and ownership and property and things of that nature kind of across the board and not within a specified category. This is due to the nature of sort of the board's jurisdiction over so many variety of businesses and enterprises in the state. These categories, the more specific categories, are narrower, in fact, because it's saying instead of having to disclose all ownership or property interests or things of that nature, it's only those coming from certain types of sources. And so categories 3, 4, 5 are a narrower disclosure obligation, and that's to reflect the nature of governmental decisions that some of positions that staff make at the agency, what they affect. So for instance, the one about media relations, we recognize that our public affairs team isn't necessarily always making governmental decisions about who we're going to enforce against, for instance. And so having them disclose as widely as positions like attorneys or the board members wasn't necessary. And so a more focused disclosure that relates to the types of conflicts they might encounter was more appropriate. Does that help? Okay. So apologies, because you remain obligated to disclose at the broadest disclosure requirement as a board member, but of course, always happy to assist with those determinations as needed.
Thank you. And for the record, Board Member Ozer nodded in response to the question of whether it helped.
Yes, thank you very much for that. Appreciate it.
Mr. Liebert?
Yes, Phil, I just wanted to get your advice. Should we fight the FPPC on this issue of that?
I don't think so. I think we should concede it and strike that, or not concede it. I think we should strike that. But
I agree.
it's the appropriate time in the process to make a minor grammatical.
Well, and we
revision.
can have a motion that authorizes staff, as usual with our regulations, to make any sort of conforming changes to the text. Mr. McTaggart?
Thank you, Chair. Mr. Lloyd, I'm sorry, this is a really dumb question. We're not adopting a standard that would require us to do anything other than fill out the Form 700. Is that correct? I mean, I just don't want to have 15 different disclosures and, you know.
That's correct, and not a dumb question at all. Again, for board members, everything is business as usual. If anything, what this does is it relieves current burdens on staff who have to sort of overly disclose in their Form 700s to make a more narrow set of disclosures when they submit their Form 700s, but it's still the exact same process for board members.
Thank you, that's fine, thank you.
All right, thank you. And just to be clear, because I realized I was the only one on the board when we initially adopted the conflict of interest policy, at that time, we only had board members and possibly an executive director. So we only had category 1, and we did have category 2, which I think was a forward-thinking category for when we hired, or we might have hired you, Mr. Laird, or somebody who was in category 2. So this is adding the categories that are appropriate to a broader staff under the Fair Political Practices Act.
Yes, that is correct. And your recollection is correct as well, because I recall that the board members were the only one who received the 45-day notice because they were the only staff of the agency at the time.
Yeah.
And before we conclude, I'd be remiss not to thank Mr. Kevin Sabo, who's in the audience today, for his efforts to get this moving. FPPC has a lot of departments and agencies to work on these conflict of interest codes with, and he helped get this to this point.
Thank you, Mr. Sabo. I won't ask if you used your radio voice, but I hope you did. That's wonderful. So the motion I will request will be to direct staff to advance the proposed draft amendments to the agency's conflict of interest code provided to us today in connection with this agenda item to formal rulemaking, including commencement of the 45-day public comment period, and to authorize staff to make additional non-substantive changes to the text if necessary, including but not limited to the reduction of extraneous that's. And with that, I will ask for public comment.
This is for agenda item number 6, discussion and possible action to amend regulation section 7500, conflict of interest code. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 6. Madam Chair, I'm not seeing any hands raised at this time.
Thank you, Ms. Carwile. In that case, may I have the motion as stated? Thank you. I have a motion from Mr. Liebert. May I have a second? Thank you. I have a motion from Mr. Liebert and a second from Ms. Hamer. Ms. Carwile, would you please conduct the roll call vote?
Yes, this is a roll call for the motion as stated by the chair. Board Member Hamer?
Aye.
Board Member Liebert?
Aye.
Board Member McTaggart,
Aye.
Board Member Ozer,
Aye.
Chair Urban.
Aye.
Madam Chair, you have 5 yeses.
Thank you very much to Mr. Laird for presenting, Mr. Sabo for pushing things along, and to everyone for the discussion. The motion carries with a vote of 5 to nothing, and it will go into the 45-day comment period. We now turn to item number 7, which is our item for public comment on items not on the agenda. As a reminder, under this item, members of the public and members of the public only may bring to the board's attention comments that they have on any matter. Please note, though, that the board may not discuss or act on any matter raised during the public comment section, except to decide whether to place the matter on the agenda of a future meeting, which we would take up under our next agenda item, number 8. We appreciate that we may seem unresponsive, but that is not our intent. We are listening, and it is necessary that we comply carefully with Bagley-Keene so as to meet the goals of both the commenter and the board. Thank you. And with that, Ms. Carwile, is there any public comment on this item?
Public comment on agenda item number 7. Please raise your hand using the raised hand feature or by pressing star 9 if you're joining us by phone. This is for agenda item number 7. Madam Chair, I'm not seeing any hands raised at this time.
Thank you, Ms. Carwile. Thanks again. And we'll move to agenda item number 8, which is our advertised item for future agenda items. As is usual, I will first touch on the regularized calendar and upcoming items, briefly run through my list that I keep from items from board members, and then request if any additional ones from board members and the public. Our next regular meeting is currently scheduled for August 7th. In today's meeting, we covered 2 regularized meetings, legislation update and request for board to take positions on certain pending legislation, and our annual enforcement update. On August 7th, we will hear from admin about the budget plan for upcoming budget development. And will we have a public affairs update? Probably, yes, we will have our annual public affairs update. I note that the regularized agenda mentions the annual hiring update, including diversity and inclusion metrics, but our very efficient Deputy for Administration, Von Chudambira, actually covered that in her last administration update. So we have already covered that one. The conflict of interest code we just discussed is anticipated probably for final decision in August. So if there's an update we need to hear, we will hear that. In November, that's the following regularly scheduled quarterly meeting, we will have our annual legislation proposals and priorities. So that's the forward-thinking discussion of potential legislation. Annual intergovernmental affairs update and priorities, the 2027 board calendar, discussion of that, and our annual discussion of regulation proposals and priorities. So I'm putting this on your radar now, just because some of those are pretty meaty items, to let you know when the usual plan is to discuss them. Of course, if something comes up, I will put it on the agenda earlier. The quarterly meetings are typically on Fridays. Yesterday, we began a series of informational sessions, which we will continue to hold on some Thursdays before board meetings for interested board members or on other days. These may include information sessions for potential rulemaking, such as that supported by our requests for preliminary information. Relatedly, Ms. Ozer has previously requested an information session on reducing friction for exercising privacy rights, and Mr. Liebert has requested one on privacy policies. Ms. Hamer has requested a discussion about audit division development and priorities. So when our chief privacy auditor is ready to present the request is open. And then we have some requests related to rulemaking. Mr. McTaggart has requested implementing the right to delete to include partial deletion, and in this case, and he's updated it to include discussing getting businesses to disclose the impact of deleting the data as it varies depending on what you're deleting from where. And requested an agenda item about how concretely we can guide consumers since we are limited by the California Administrative Procedures Act and Bagley-Keene. I mentioned discussing whenever we're ready and gathered more information about employers, employees, and models for businesses, model notices, and so forth. We've been discussing GDPR adequacy, and we have a plan for that. And there's interest in discussing what a small business is and who's actually covered by our laws and regulations. And that is my list. Do board members have additional items they'd like to add? Yes, Ms. Hamer.
So,
Okay.
the November meeting, there was a public comment about a fourth party issue. And
Oh, shoot, it's here. I forgot
Okay.
to read it. Yep. Go ahead, so I don't cut you off.
go ahead.
Oh, okay.
I have more, but go ahead.
Okay, so a legal briefing on the fourth party issue, which was brought up in a public comment, right?
Yes.
Yes, okay, it is on my list. I just missed it in my readout. Okay?
I don't know if this is a legal briefing or something else, but the combination of technical devices that record and do facial recognition, i.e. the Meta glasses and things that operate like that, or even recording things that can run through facial recognition, just the cross-section of how we can protect consumers' privacy with those technologies. And then I have, that's it. Oh, wait, no, I had one more. Sorry. I would be interested in a future informational session on AI or Gen AI and the impact protection of California residents' privacy rights.
Mr. Liebert?
Is our next meeting, just remind me, please, in August, is that one down at Riverside or?
I think it's currently planned for Riverside, yes.
Great. I don't want to jump ahead of anyone, but I'm hoping that we can soon have an informational hearing on the notices and disclosure issue that I know our great staff is evaluating. So I was curious, Mr. Laird, what your thinking is in regards to, with our exciting informational components now, how that's going to work vis-a-vis all the work that you and your staff are doing on these issues of potential regulations.
Great question. I think our plan is to pair our future agenda items on those topics with informational sessions to sort of better inform the board on the topics before staff itself then presents on potential recommendations on that work.
So as you know, I'm enthusiastic about us doing that for an informational hearing. The other issue that I would raise now is one that I mentioned, I think, earlier, and that is the impact of advertising models on AI platforms in terms of its impact on privacy. That seems to be the brave new world we're entering into shortly, and certainly something that its interface with CPPA and all sorts of other privacy issues would be great to start evaluating at some point.
Are you thinking, Mr. Liebert, of that as part of an informational session?
Yes, absolutely. I think it's going to be absolutely huge. People now who are used to this happening, advertisements on social media platforms, and now the idea that everything that they're putting on their AI investigations being subject to an advertising model as a potentially really important issue.
Thank you. Additional items? Ms. Ozer, please go ahead.
Just one building on the executive director's very helpful presentation about sort of spreading the word about the resources of the agency and of the DROP platform. And then in the enforcement presentation, there was conversation about how when there were some significant data breaches, there was a lot more traffic to the agency. And so I just wanted to maybe suggest there could be an opportunity to consider whether or not, if there was a data breach notification letter that went out to Californians, whether that could include information about the agency and agency resources and the DROP platform. I do remember getting some data breach notification letters in the past that had information about the resources of the Federal Trade Commission and others. So given today's conversation, I just wondered if that could be an interesting opportunity to make sure that Californians, when their information has been potentially disclosed, know about resources and about the DROP platform.
Thank you. Mr. McTaggart, I just want to be sure I haven't skipped you.
No, I think the resources of the agency are constrained enough that I don't need to add something else. And plus, once we deal with the adequacy and we've been talking about the do not sell stuff, I think we're good for me anyway.
Okay, thank you, Mr. McTaggart. Are there any additional agenda items from members of the public?
This is for agenda item number 8, future agenda items. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 8. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Carwile. In that case, we will move to agenda item number 9, which is our closed session agenda item, in which we will discuss personnel matters under the authority of Government Code Section 11126 Subdivision A1, and also confer and receive advice from legal counsel regarding litigation for which disclosing the names would jeopardize the agency's ability to conclude existing settlement negotiations to its advantage pursuant to Government Code Section 11126 Subdivision E1. And the remaining agenda item after number 9 is adjournment. So for the information of the public, we will go into closed session to discuss these items. We will be returning to adjourn, but only to adjourn, just to give you enough information to make a decision about whether you want to stick around for that. Thanks, everyone, and the board will now go into closed session. Welcome back, everyone. We are returning from closed session, item number 9, and moving to item number 10 on the agenda for today, which is the last agenda item, and it is adjournment. I would like to thank everyone on the staff who put together all of the wonderful work and materials that we heard from today, the board members for their time and attention, and members of the public. With that, may I have a motion to adjourn this meeting?
I'm going to make that motion, and I'm going to thank you for great sharing as well. I so move.
Thank you, Mr. Liebert. May I have a second?
I'll second it with an affirmation of Mr. Liebert's comment.
Okay. I am being very flattered today. I have a motion and a second. Ms. Carwile, would you please conduct the roll call?
Yes, the motion is to adjourn. Board Member Hamer. Board Member Liebert.
Aye.
Board Member McTaggart.
Aye.
Board Member Ozer. Chair Urban.
Aye.
Madam Chair, you have 2 present yeses, 1 virtual, and 2 absents.
Thank you. The motion carries with a vote of 2 present in favor, 1 remote in favor, and 2 absent. And thank you again to everyone. With that, this meeting of the California Privacy Protection Agency Board stands adjourned.